Thursday 4th. One three. Yeah. Tomorrow may not be possible. Tomorrow it's not possible. No, tomorrow not possible. Right. List and the request made by land constituents 13 to Friday. What is the date? 5th 9, 5/9, 5. Further, the registry is thereby directed to reflect the name of the learner IH site. For the petition, tomorrow, we have to
Honor,
4th, at best 4th.
at court.
No, 4th of September.
4 to
not
September,
4th.
yes, Your Honor.
Right, Lordship, I beg to mention for listing one criminal petition, Your Lordship. For motion, it was listed on 26/6, Your Lordship. On that day, due to some urgency, unavoidable service, I have to adjourn the matter, Your Lordship. On 8th of September, Your Lordship.
Maybe, Lordship. I beg to mention for listing one IA for suspension of sentence, 5 years conviction. This week, my lord, for
Maybe by 8 or 9. 8
4 or 5 million.
8 by 8.
8.
8 of September.
One is my lord, criminal petition, my lord. This is matter on 2022, my lord. And next week, any date?
Approach registry also, it's not possible for every matters to be listed. It's not
Next week, any
possible.
date, my lord. Next week, my lord. Not in
Huh?
this. Next week, my lord. And next week,
9 or
11.
11th of September.
Population.
Wait, please, Your Lordship. Lordship, I'm praying for listing up to admission. Any date on 10 or 11, Lordship?
11th.
May I please, Lordship, for listing of admission, Lordship, criminal petition, any date of 10 or 11. Pending matter 2021.
11th of September.
Similar
Actually, what is the problem? The date is fine. Demand is not with our problem. মোশনে যখন আমি লেখা থাকতে কেন আপনি তবু মোশন আপনারা তিন চাই করেন পেন্সিল I ordered double level correction.
May I please, Lordship. I beg to mention for listing one criminal petition for admission matter. This matter was supposed to be listed after 2 weeks. There is urgency, but 1 month is left, my lord. Not listed. Any date, madam.
10th of September.
May please, Your Lordship. I'm praying for listing one freshly filed criminal petition for motion, my lord. Day after tomorrow on Wednesday, my lord.
No.
Urgency is that, my lord, the.
Already we are overburdened with the motion matters. There are today also 26, 27 only motion matters are there. It's not possible to
Friday, madam.
cover all the matters.
Friday, my lord.
Not possible.
Any date, my lord, and next week.
9th of September.
Maybe, Lordship. Lordship, I beg to mention a criminal revision petition, Lordship, for admission.
11th of September.
Keep your place.
Yeah, please, Your Lordship. I beg to mention for listing of a bail application, Your Lordship. On 5th, Your Lordship.
Bail application.
Yes, Your Lordship.
No. We are not, it's a not regular bail. Make a mention before Justice Kalita, court number 16.
It's a mention for listing of a IA in a criminal appeal. On the 3 occasions, the IA has not been reached. Any date your opinion is quick on Friday or on 3 occasions it has not been reached for the day.
Both these. Many matters are there. Maybe on 10th.
On?
10th of September.
10th.
Otherwise, it won't reach. Again, same problem.
May I please, Your Lordship? Lordship, I beg to mention for listing, Lordship, one criminal petition, Lordship, for others.
Any date, after 10, Lordship, 10th of September.
After 10,
Yes, Lordship.
1/5. 15.
1/5.
Yes.
May it please your lordship. Lordship, prayer for listing of one transfer petition, lordship. Any date as per lordship.
Pardon? 15th of September.
Oblige lordship.
May I please, your lordship? I am praying for one criminal petition, my lord. Well, this petition, my lord, lived over on 27/8, my lord. Well,
We don't
on
have it.
Friday, my lord.
No, no, not right. These are all matters that are overburdened with all emotions. Cannot. I must take fever.
Oblige.
5th of September.
Huh?
5th.
Yes,
05.
yes.
Please, your lordship. Lordship, I beg to mention for a listing of IA of criminal revision petition, lordship. Lordship, kindly on tomorrow or
No,
day.
not at all.
Lordship,
Not possible. No tomorrow, no Friday, nothing. At this, yes, 8th of September.
May it please, your lordship.
Only
I am praying for listing of a IA criminal, which is for suspension of sentence and for bail
whatever.
in criminal appeal, lordship. Could it be on lordship 8? It was last listed on April, in the month of April, lordship.
9th of September.
Lordship 9th, some difficulty on
You have
8, lordship. 8,
8.
oblige.
May it please your lordship, I beg to mention bail application number 1590
Make a
2025.
mention before court number 16.
Your,
Court number 16.
your lordship, actually the co-accused was granted bail by your
In
lordship on.
that case also, you make a mention before court number 16, it will come before this court. We cannot mention.
May it please your lordship.
My lord, there is criminal petition, my lord, pending in this court, my lord. My lord, in the meantime, my lord, 3 days back, my lord, warrant of arrest, my lord, issued, my lord. So, my lord, necessary some order, my lord. Wednesday, my lord. Warrant of arrest issued, my
Warrant of issue arrest.
Yes, yes.
Maybe arrest. You should know what to do.
On
Warrant of arrest
Wednesday,
may issue. Then,
Wednesday, my lord.
no. I think. Court.
Court, no.
Analogous matter is fixed tomorrow. Bail application number 264, accused file a bail application
Bail application number
2619,
2619.
lordship, 25.
25.
It is fixed tomorrow. CD was confirmed. So both the matters may be taken up tomorrow.
This tomorrow. Issue property is day liquid. Fix on. I'll do the second, so it's along with PA number 261.
Declare.
Please, your lordship. Mr. 42 bail application, lordship. Mr. petitioner is 53 days behind the bar, lordship.
How many?
53 days, lordship.
3 days.
Lordship, FI is related to fake currency, lordship. Lordship, another co-accused is
No.
granted,
I don't know fake currency. There are sections.
lordship.
489C are there, then the, I don't know, 489A, B. I mean, confusion. Yes, 53 days. Now, yes,
Not
that's when it can be.
Another co-accused has granted bail, lordship. Which I am paying for short debt, lordship, for case diary.
Just a second.
Lordship.
Yes, that's when.
on that, on 10.
10th of September. 10th of September.
Lordship. Must
Will be called for 10th of September.
Yes, sir.
May it please your lord. This application was earlier also, your lordship rejected it. Last order, page 34. 36.
36.
Before going to that, certain things were not correctly placed before your lordship. Lordship will see page 36. Third paragraph, page 36. Lordship got it. Mr. Borthakur submitted that the white order dated so-and-so on the prayer of the so-and-so 111.2 and 111.13, 114 BS has already been added against the present accused petitioner, which is thoroughly wrong, you know. The application filed before the court does not contain this. Page 31. This is very unfortunate, you know. We entirely rely on public prosecutor so far case that is concerned. Research the application, Annexure 5, page 31. Here the names are mentioned against whom sections are added. Number 1, Aminul Haq. Then Miller 3, Shahidul Islam. Is that a document? Lutfur Rahman. My name is not there. So those 3 sections are not added. They should be very clear about it, Miller. Then Miller, your lordship may kindly come. FIR does not contain my name. Page 41. 14, page 14. My name is not there in the FIR. These are 2 most important documents which do not contain this petitioner's name. And it was not disclosed to your lordship. Lastly, Miller, your lordship will find, kindly come to your lordship's order. 36. Page 36. Page 36, last line. Considering the, your lordship got it? Considering the nature and gravity of the offense, I do not find a fit case to grant privilege of bail to the present petitioner. My lord, the Supreme Court has laid down more than 7 or 8 points to be considered. The lordship has considered only this one regarding regarding grievous offense. And then, my lord, other persons are whose names were added later on, or whose names were found in the last occasion on the case diary. They are already released on bail by the learned session. So in view of this, my lord, forget about that bail given, my lord. But these things are basically error on the face of the record. And my lord, I have already completed 83 days. They have not been able to give any search sheet or whatever.
You are 83 days in custody.
83 days.
Lordship, here firstly I want to state here, Lordship, one of the section is 313, which is for punishment for belonging to gang of robbers. And whoever belongs to any gang of robbers associated in habitually committing theft for it. And in the 36, page 36, may I read, Lordship, some few lines. Mr. Borthakur, so and so, Lordship, submitted in this record, there are sufficient incriminating material against the present petitioner, and on inquiry, it has come to light the petitioner is a professional thief and he is working in an organized manner and is actively involved in similar ATM card swiping sweeping incidents. The modus operandi involved in the fake ATM cards in the name of some suspected individuals, where they formally targeted elderly persons in ATM booths and decidefully engaged them in conversation, then sweeping the victims' original ATM cards with a fake one. Moreover, Lordship, then after a few fourth para, Lordship, moreover, so it is submitted that there are other cases pending against the present petitioner involving similar kinds of offences, and he is habitual offender. And here in the 313, Lordship, it is stated associated in habitually committing theft or robbery, Lord.
These are only on the submissions of the public procedure. Where he got it? Record does not show that.
It is there, Lord.
Now,
The-
now he cannot say because he is not.
It is
available.
not there, Lordship.
These are the submission he is directing from the other earlier submission, but at present he is not in a position. One thing you can do, 83 days, we are saying 83 days. So at 2 it can be taken up. If you can get an instruction, any instruction regarding the charge sheet.
Short date may be given, Lordship, one time may be given to me, Lordship, to bring the CD. Whether it is not or whether it is there or not, I can then only state on that.
No, Miller.
In that
Or any
case,
new grounds, otherwise new ground has to be there, Lordship.
Your
it
lordship.
seems there is no new grounds, 2, 3 grounds are there.
Lordship.
That there are some misleading statement from the public prosecutor regarding the adding of sections, and now Mr. Bhattacharya has submitted that adding of section with some 3 particular accused person, not against, maybe, I don't know, we have to go through. But the question is that it will come within 1 week because 83 days he is in custody.
In my opinion, it is 80
So,
days, Lordship.
Coming-
Anyway, Lordship.
Sorry,
In my opinion, Lordship, it is 80 days,
18.
Lordship. Anyway, Lordship, otherwise.
It's 83 days.
Okay, Lordship.
Please calculate, don't submit wrongly.
Okay, Lordship,
11/6. 11/6.
11/6,
11/6. So that comes to today is 83rd.
83rd.
So what is this, Miller? From record they submit wrongly. Please read little bit of your public procedure.
Can it
There's
be
nothing
listed
wrong.
by 4th or 5th? Can it be?
Lordship.
Miller, your
We
lordship.
Try that.
Lordship.
And even if suppose it doesn't reach, then take the instruction regarding the charge sheet, whether it's charge sheet because 80, 83, whatever, it has already.
They are not submitting the Miller case diary to the session court. On fourth occasion. What is this?
Not submitting means
Case diary. It was called for by the session judge also. There also it was not produced.
That's why they.
That's why they were released on bail. But here their record says that I am not involved. Why he can't explain that? Name was not there, FIR does not contain. Then on what basis I argue the case? This is very unfortunate.
No, FIR doesn't contain your name because obviously it may not be.
All right, then
Investigation.
That is one of
during
the
investigation, it has come out.
no, that is
that
one
you
of
are
the
involved.
one of the considerations of the bail.
Pardon?
FIR does not contain name. That is one of the considerations of the bail.
Yes, obviously, in some occasion it may be the
And
it
then
may be
Miller,
the occasion when
then
there may not be name, your name may not be.
then Miller, the application filed for adding his new section. Why his name is not there?
This is pending.
No case is pending against me. Let him show which record, which case number.
There are some
That is
case
why I have to
numbers.
look into the CD. That is why, Lordship, I have to look into the CD, whether it is there or not.
Because the public prosecutor will not look into the CD, that's why my liberty will be curtailed. This type of submission should not be allowed to be made.
4 or 5 can be?
Not 50.
5th.
Fourth,
5th will be how many days? Yeah.
Almost 84 days. Fifth will be there some problem. He won't be there. Can it be on 4th?
Okay, then we'll try. 4th, but I don't know. You try, just try. I don't know whether it will reach or not.
Not joint proceeding.
No, Kamrud Metro.
Kamrud
That's
Metro.
what I'm saying. But CD, whether okay,
No.
then we'll try it. We'll try. Both को ही तो सुनिए. Hard Mr. Bhattacharya. Dilanet Senior, assisted by Mr. Assisted by you, J. Ahmed. J. Ahmed. J. Yeah. Also heard Mr. Anandas Dilanet additional. Please take matter on 4, 9, 2, all for the case. City.
May I please, your lordship? Lordship, the petitioner had earlier preferred one bail application before this honorable court. And in that bail application, lordship was pleased to dispose of the bail application by order dated 5/8/2025, directing inter alia directing the petitioner to appear before the learned trial court at Morigao. And accordingly, with the order of this honorable court, the petitioner appeared before the learned trial court, and the order passed by lordship. I am reading out lordship in the last paragraph. Order dated 5/8/2025 passed by lordship.
Which
Considering
page
the
number?
submission made by the learned
Just,
counsel
just
for
page number, page number.
page number 24, lordship. In the last paragraph, lordship. Made by the learned counsel for both sides, and also considering the fact that the case diary has already been charge sheeted. By charge sheet number so and so dated so and so, the accused petitioner is hereby directed to appear before the learned court below with an appropriate application for regular bail, which shall be considered by the learned trial court in accordance with law. Thereafter, lordship, the petitioner appeared at Morigao, but the bail application that was preferred by the petitioner, he is also in jail now as of now, was rejected. Lordship, that rejection order passed by the learned court of session judge at Morigao is at page number 26 onwards, lordship. May I read it out, lordship? The case record received on committal for disposal, the accused of Fazul Ali Hussain is produced from judicial custody. Seen the petition number so and so filed by the petitioner, so now paying for bail of accused Fazul Ali Hussain, who is in judicial custody since 25/6/2025 in connection with the above case. The contents of the petition states that the petitioner has filed an application under section 483 of BNSS before the Honorable Guwahati High Court, praying for bail of the accused. Accordingly, on 5/8/25, the Honorable Guwahati High Court passed an order directing the petitioner to appear before this court with an appropriate application for regular bail. It is further contended that the accused is innocent and falsely implicated in this case, that if granted bail, he will not hamper or tamper any evidence or witnesses. I have heard both sides. I have gone through record. It is seen from the record and from the statement of the victim recorded under section 183 of BNSS that the accused established physical relation with the victim on the pretext that he is Hindu by religion. After establishing physical relation with her, he took some obscene photos of the victim and later on tried to extort money from the victim by blackmailing her that he would make the photo viral on social media and he would kidnap the daughter of the victim. Thus, I am of the considered opinion that it is not a fit case to grant bail to the accused at this stage, as there is every possibility that he may repeat the offense as committed by him and he may dissuade any person acquainted with the facts and circumstances of the case from disclosing such facts to the court. Accordingly, prayer for bail of accused of Fazul Ali Hussain is rejected at this stage, fixing so and so for production. Now, lordship, when this honorable court was pleased to pass an order in connection with the earlier bail application, it was evident that charge sheet has been filed. So obviously there will be a 164 statement, and the informant, obviously she will make her statement in such a way that it will support her case. But then also, lordship, if lordship wants to go to the 164 statement, lordship, it starts from and medical report, page number 28 to page number 44, and extra 5 and 6. Now, lordship, I have annexed the type copy, translated type copy. It is page number 28, type copy. My name and may I read out, lordship?
No, it's okay. I have to.
Yes.
In Chennai also they live together.
It is high.
Chennai also.
Yes. Yeah.
Yes,
Now,
sir,
lordship, in my humble submission, the undisputed facts of the prosecution case, since charge sheet has been submitted, 164 statement has been taken. The undisputed fact, lordship, is that the informant, she is a lady aged 35 years, whereas the accused is aged 27 years. The informant, she has a daughter aged 12 years, meaning thereby that she is married. The informant herself says that out of love relation of love, they were into physical relationship, meaning thereby that if there was any relationship that was consensual. So in my humble submission, Lordship, the act of the informant herself is promiscuous, immoral, and it defies the very institution of marriage, Lordship, because she was into a valid marriage when the alleged incident took place, if it has ever taken place. In that case, Lordship, the informant will not be punished. She will be pardoned, and the accused will be punished. That is unfair, Lordship. And by now, it is almost near about 70 days that he is in jail. So my humble prayer, Lordship, may kindly be pleased to
Yes,
grant
Lordship.
this.
However, if you look into the 183 statement of the person, Lordship, the deception is there, Lordship, because he has some deceptively.
So what is the charge has already been framed here?
Charge, Lordship, yes, on the last date, charge hearing was there, but I am not aware of that order.
Let us periodic case record. Can copy of the case report of registry will do it. List accordingly when it can be listed. এনেকুৱা order টো ইয়াতে আহিব লাগে মই বুজা নাই এইটো মেৰিট ডিসপোজিং হোৱা নাই it was not meant disposed on merit মানে anyway কেতিয়া মানে ডিপেন্ড ফৰ মৰি second 10/9 will do 10/9
Pardon, Lordship.
10th of September this month
Lordship, my humble prayer, Lordship, may kindly be pleased to grant the bail, because whatever I have annexed the certified copy.
no 10th of September next
Please. Deeply obliged, Lordship.
May I please, Your Lordship? Lordship, this is second bail application. CD may be called, Your Lordship.
certificate copy. Yes, 12 can be 11.
Obliged.
May please, Your Lordship, the criminal revision petition, Lordship, agrees the order, Lordship, the phase 9, Lordship. The husband order the maintain. Only, Lordship, my humble prayer, Lordship, the only I pay the maintenance, Lordship, date of the judgment. This is the prayer, Lord. But in this order, Lordship, the date of filing, Lordship.
See, there are some criteria for whose default, how it got delayed, and what was the condition of the first party or the petitioner. These are taken into consideration while passing the order from date of order or from the date of application.
Yes.
So at this stage, we are not in a position to say anything. So what was the amount, quantum?
The first interim maintenance 1,000. The petitioner regularly paid, Lordship. The date of judgment, the said order is recalled, and the date of filing of the petition, Lordship, the
So now
3,000.
now what is
3,000 per month.
3,000?
I
That
pay
means
the 3,000, Lordship, only date of
whatever, that
judgment.
means 3,000 you are paying now.
Yes,
You are
Lord.
paying 3,000 now?
Yes, Lordship.
You are
That,
paying 3,000 now. And even if it is some from, suppose from date of filing, in that
Date
case
of-
also 1,000 will be deducted because you are already paying.
Lordship.
Those will be deducted. So I don't think any thing is required.
Only prayer, date of judgment, Lordship.
No, this is your prayer.
Yes, Lordship.
You have to hear the other side also, na?
Lordship.
We are issuing notice only because it's a maintenance case. We don't want to pass any order or stay there.
Stay, Lordship.
Stay we cannot pass. Stay we cannot pass such kind of nature of case, especially deviate, maintenance. Either we are not paying. I mean, we are not passing any order. So issue notice going to hard Mr. and Amit with an account for the petition. This is an application under section 442 PNSS, dated section 528 PNSS against the impun judgment and order dated 5/5/25 passed in FC packet of criminal case number 245 of the 2023 by learned principal Judge Gamble Court, Water, whereby the petitioner was directed to pay rupees 3,000 per month as monthly maintenance to the respondent by from the date of filing the petition. Issue notice to the respondent to register area and also call for the scan copy of this. Please the matter the petitioner will take steps within 2 to 3 days. List the matter accordingly after 2 days. We are listing it on
Lordship,
cooperatively
the
short date.
only still Lordship, the page number 15, Lordship, last line, Lordship. It is made clear that while the calculating the area, Lordship. I pay the 3,000, Lordship, the only is the area, Lordship. After hearing the till disposal, Lordship.
Page number 15. Where is the
15,
area?
Lordship, the paragraph 16, Lordship. It is made clear that while the calculating the area, maintenance of the entire maintenance.
Yes.
The
Definitely,
only,
there is a rightly passed the order.
yes, Lord.
While calculating the area, that 1,000 you have already paid, that will
Paid.
be deducted. Very,
Deduct.
very good order.
Lord.
That will be deducted. List after 3 weeks.
Diploma.
And appears on call. And appears the petitioner. Yes, some line. And appears on call for the petitioner as well as respondent. Is the matter according to rules as on the date.
Very briefly, Lordship. This female division is challenging the order dated 35/25, Your Lordship, whereby the original order has been maintained by the session court, Your Lordship. Page number
Page number
30 is the imping order, Your Lordship.
3. So where is the order? You have challenged?
The page number 38.
Oh, 38.
Sorry, 38. The trial court order has been maintained, Your Lordship. A distant notice may be issued, Your Lordship.
So appellate court that appeal the order of
Appeal the order.
NI case.
NIPS.
What do you think? Is there any possibility of any?
There is Lordship. Lordship, there is various contradictions in the case, Your Lordship.
No. Possibility of any this
Settle.
Sorry, not husband. This amicable settlement or before mediation. Is there any possibility?
There might be during.
Hardship. And also part. And still an education. This is an application of 642. Under section 528 NSS against the implement judgment and order dated 30/05. By the Planet Court of Section just notified in criminal appeal number 14, where the conviction of the appellant is upheld for the offense and section 152. issue notice on the respondent. No formal notice is required to be served on the state respondent number one. How a copy of the sub may be a copy of the petition may be served during also called for the TCR of both the records of learned both the records from the court of learned session judge as well as learned petitioner CTM law. List the matter according to courts.
There is IL.
Are you on still on previous bail or what?
Yes, she is in previous bill.
Or
In the meantime, warrant has been issued.
So if warrant is already issued, then you are not in previous bail. The judgment was passed on criminal appeal judgment was passed on appellate order case
3525.
T05.
Yes, 3525. 305.
And you have filed this one within limitation.
Within limitation.
So where from you're saying that you have already warrant has already been issued.
It's supposed to have no order has no order with me alone. Yes,
When the case was fixed, pending before the appellate court. In that case, you were on previous bail.
Yes, I am in previous.
You were on previous.
I am previous.
I heard Mr. Archie done consultation and also heard Mr. and last done a question. Next, brother, this is an application of the reportedly for suspension of sentence pending suspension of sentence during the pregnancy of connected criminal examination referred by the present petition and also with a prayer to remain him on previous. Submitted by Mr. Chetty that the petitioner was initially convicted by the learned court of petitioner CGM Nalbari by its judgment and order dated 27/02/2023 in connection with NI case number 69 of 2016 and section 138 of the NI Act, sentencing him to undergo SI for 1 year and further sentence to pay rupees 3,70,000 towards compensation. The petitioner referred an appeal before the learned session judge, Nalbari, and the order of the additional CGM Nalbari has been upheld by its order dated 30/05. The present connected revision petition is also connected revision petition is also filed within the period of limitation and till the date of the order. The present petitioner was on previous bill. Next, Vara, in view of this, considering the term of sentences and other aspects of the case, the petitioner is hereby allowed to remain on previous bail till disposal of the connected petition. And further the operation of impugned judgment and order. Impugned judgment, no, impugned judgment and the impugned judgment and order and the sentenced passed in appeal number
14, 20, 20, 23, 23.
criminal appeal number 14
14,
of
1.
2023 as well as the order judgment and order as well as the operation of judgment and order dated 27/02/2022 passed by learned edition CG in NI case number 16 of the 2016 Asia by state of which suspended with disposal of the connected petition. With the above observation, the ayes tested.
Oblige, that's like.
My lord. My lord, I'm appearing on behalf of my senior Mr. K. Bhuya, my lord. My lord, herein I'm the petitioner, Saiful Ali. My lord, I'm seeking for modification, alteration of impugned common judgment dated 11 July 2025, my lord. My lord, if I may kindly direct your attention towards the said order, my lord, on page number 23. My lord, if you see paragraph 4, my lord, you'll observe that it has been shown that I'm a daily wage earner and my monthly income is 8,000 rupees. However, even upon knowing this, my lord, the learned family court has asked me to pay a maintenance of 8,000 rupees, my lord. I've been obligated to pay a sum of rupees 8,000 every month, even though I'm earning only 8,000 rupees, my lord. My lord, the learned family court has relied on the judgment of the apex court, my lord, Anju Garg and another versus Deepak Kumar Garg. My lord, it is held by the Honorable Apex Court that the husband is required to earn money even by physical labor. My lord, it is pertinent to observe that the labor market is market driven, my lord. Only when there would be a demand for my labor, only then I can go and work, my lord. The said amount of 8,000 is not a cumulative average, my lord. At some months, I earn only 2,000 rupees. On some months, I earn only 1,000 rupees, my lord. Even then, my lord, the learned family court has demanded 8,000 as an obligation, my lord, which I'm in no position to pay, my lord. The thing is that I also have a second wife, my lord, and 2 sons, my lord. And my mother, who's widowed, my lord, I have to maintain them as well, my lord. Now, the thing is that if I have to pay all the money to my first wife, tomorrow my mother is going to approach the court for maintenance. And then how would I do that, my lord? Therefore, my lord, I'm willing to pay 4,000 rupees as my obligation, which I do understand, my lord. But paying all the money is not possible, my lord.
So see, these are that means 127 was fine.
Yes, my lord. Yes, my lord. Earlier, I was paying
Initially, what was the amount?
my lord, 600 for my first wife, my daughter and my son. However, my daughter is now married, my lord. So her husband is maintaining her now. So now I'm only paying for my first wife and my son. 8,000, my lord. I'm earning only 8,000, my lord. How can I pay 8,000 rupees? All the money if I pay, how would I sustain myself, my lord? And my lord, the daily wage market is also market driven, my lord. Only when there would be demand. I do understand that the learned family court has relied on Anju Garg and another versus Deepak Kumar Garg. I do understand that I'm able-bodied and I am willing to work, but how would I get the work if there's no demand? We have seen that the incessant rains which have occurred over the past few weeks, my lord. How would I get work under those conditions, my lord? The judgment which has been passed is in relation to the conditions of Delhi, where it only rains 1 month in a year. Here, my lord, only 1 month it doesn't rain. Rest 11 months it rains only.
You are Mr. Your good name.
M. Hazarika, my lord.
Mr. M. Hachari, yeah, Mr. Yeah.
My lord, it may be decreased to 4,000, my lord. Then I can pay half my money. I am willing to pay.
Give me a bit expense. This is an eligible, this is an application. Making expense. Seeking alteration of the modification of the Indian common share. An order dated 11/7/2025. Passed in this case number 210. 2023 and its case number 312 of the 2020 arising out of FC criminal case number 367 of the 2010 and the section 107 series. Issue notice to the respondent to register APN and process. Also for the extent of the weeks. Next, submitted by Mr. Hajarika that the weight count and his earning as a total his earning is only 8,000 per month. And apart from the present respondent and her son, he has the burden to look after his second wife, children, and aging partner. Earlier, his the maintenance allowance was at rupees 1,200 per month. He was regularly paid. But by the order dated 11/7/2025, it has been suddenly increased to 8,000 rupees from rupees 12,000. However, he is still ready and willing to pay the maintenance allowance if some modification or some modification is done. Accordingly, he submitted that at present he may be allowed to pay 50% of the awarded amount, that is 12,000. Next, considering the submission made by another. Other aspects of the case, let the present petitioner be allowed to pay rupees 5,000 per month till the disposal of the connected, till the disposal of the present. List the matter according to this. We're listing it in 4 weeks, with a reduced, and you are going to pay 5,000 per month.
Much obliged, my lord.
Yes.
May I please, Your Lordship? This instant application has been filed seeking interim custody of a night super bus seized in connection with NDPS case by the Jillai police officials, Karbi Anglong Lordship. Now, in this case, the case has already been charge sheeted one, and the bus is lying under the custody of the Jillai police officials since the last 9 months, Your Lordship.
As being the case has already been charge sheeted.
Yes.
Have you paid any custody before the learned trial could be?
Yes, Lordship. The same is not been considered, and I have filed this revision petition on the ground on the impugn order dated 10/7/2025.
Where is the order?
The order is annexure annexure E, page number 40 and 41. No, Lordship, annexure C, page number 17.
Page number 7.
17. 17. 17.
Village no, 17 villages. Division 5 3 5 7 3 7. Without your name it.
Page 38, Lordship.
Yeah, that's what, sir. What? Anyway, this is the rejection order.
Yes, this is the rejection order. And Lordship, the same has not been considered. And I am before this honorable court, Lordship, because I am not an accused to the instant case. Neither any.
If you go by the order, yes, Mr. Kusami, you have
Yes.
already done.
Yes.
Most probably, there are some secret chambers are also.
Secret chambers were there,
The
ma'am.
main crux of the case.
It's main crux of the matter. So that has to be decided as per the judgment rendered by Biswajit Rai. So that has to be considered whether from the CD whether how he is been involved or not.
And that apart, as case has already been said, we don't know whether is there any confiscation, these things as per you, do you have any information in that regard?
Yes, Your Honor, Your Lordship, there is a confiscation a letter pending before the Honorable Session Judge or Difu. However, Lordship, even if there is a secret
Therefore,
chamber,
the consideration of this confiscation order is still pending.
yes, and it will be, Lordship,
Because the chambers are there, na?
Chambers are there.
Secret chambers are
Cannot.
Lordship, even if there is a secret chamber, Lordship, now the question that arises is that is custody of that bus in
That's what I'm,
question?
again, second question was my question. Second question is whether there is a confiscation. You said yes, there is a pendency. That's
Pendency.
what I'm saying.
Yeah.
If there is again the question of this confiscation proceeding is there, then obviously it may not be a case that directly we cannot allow it because we have to see anyway. We are calling for the case diary, case record.
Case record.
So definitely this petition may be pending before the court and report from IO may not be possible, but one report may be there.
No.
Whether there is initiation of any confiscation.
Yes.
That report can.
Yeah.
Lordship, even when a bus is further custody of
Say
that
bus
bus
is for carrying the passengers. So
Yes.
you are you're carrying the contraband.
thing is, my bus, I have given my bus to one transport agency, namely Trishul Travels. I have annexed that petition, that paper also, that it was under their custody. Even if there is a secret chamber, that is not within my knowledge. The bus were looked after and the route were decided by the Trishul Travels only. In that circumstances, even if there is a confiscation, this seizing procedure, I'm not aware of any secret chamber to be built in that particular bus in question. So I, being the owner, at least the further custody of the bus in question may not be required at this stage because it is already charge sheeted. And the investigation is not necessary. Had it been
Let
lodged,
records be there, ma'am. Then you can decide now whether
Lordship,
how he is involved or otherwise.
Lordship, in the Biswajit judgment, your Lordship is well aware of the judgment. That has been discussed. That has discussed that even if that is not within the knowledge of the driver, not within the knowledge of the owner, then in that case,
There in Biswajit also there are some categories. The
Yes.
categories are there.
Yes.
How is knowledge will
Yes.
definitely you cannot say that I didn't
Yes.
have any knowledge, but there has to be some findings or some recordings or
Yes.
some evidence
Yes.
wherefrom we can at least say assure that
It is
it
as-
was definitely it was
Yeah.
not within his knowledge. That has to be there for the driver's statement. As you have submitted your this company or the
Yes.
transport company,
Yes.
these evidences
That will
they also
will
be
the
required.
record only. otherwise-
Biswajit, these are all discussed, I think.
yes.
Yes.
Let us see.
Even
So
if
maybe
not-
right also.
in the instant case, another accused person was arrested based on the confession of the prime accused person, namely Pashan Ali, and who has already been enlarged on bail. But Lordship, had my name have been implicated by the accused person, I would definitely been made an accused to the instant case. But in this case, in the charge sheet also, nothing against me has been discussed. In such
You are
circumstances,
not a charge sheet.
no,
You are not a charge sheet accused.
no,
But a case is already been charge sheeted.
yes,
Against you, it is not charge sheeted.
no,
But whether there is any column, that case is still pending.
No.
Is there any?
no. I have
No,
annexed
I
a charge
don't know.
sheet.
I don't
I have annexed a charge sheet.
That is why everything will be clear.
heard MS Albonic, the Daniel Council for a petitioner. And also heard Mr. MP Goswami, the Daniel additional PP appearing. Short video. Call for the scan copy of the case record, as well as a report from the investigating authority as to whether any confiscation proceeding has been initiated against the confiscation proceeding is initiated for the bus in question, for which the present petition for Jimma has been filed. More so, the learned court below would also furnish status report of the case as to whether any order of confiscation was passed by the learned trial court. States. List the matter accordingly, when it can be listed for.
Lordship,
Well-
the instant case is fixed before the Leonard trial court on 9th of September. Before that may be fixed.
No, before, after will not hamper you, I think. Maybe before, maybe after, but it will not hamper you. It will be my record, I don't know. It's not
Are we on
be possible. I
date that?
it is difficult. What do you want? No, no. No, the people are 90 days to us. 11, 12 months, finally. 10th of September.
Lordship, call for the records.
Yes.
Lordship.
Records and the order we had submitted the day from the, I also one report may be called for whether any conflict proceeding.
Yes, yes.
And that part, Leonard trial court below is also asked whether there's any order on confiscation was passed by the.
Yes.
That will clarify the record.
It will-
Met, Mr. Lordship.
Yes.
Lordship, here petitioners are the husband and wife. They are living peacefully, my lord. Out of child marriage, my lord is very much aware. Around more than 4,000 cases has been lost over the night. My lord, petitioner number 2 months is the wife. My lord, while she was just below the 18 years of age, she was married. He was the love affair with the accused petitioner number 1 and eloped with the petitioner number 1 and married, my lord. Now they are living very peacefully, blessed with a child, my lord, of 2 years, my lord. My lord, they
Who is
come up.
Pierre? Pierre Ali is her father.
Pierre Ali is the secretary, VCDC, VDP secretary.
VDP
He is a stranger, my lord. He is not, he has nothing to do. He is a third person, my lord.
No,
He-
I don't know third person or fourth person, but he is the informant.
Informant, my lord, but victim is here, my lord. Victim and the petitioner, they are
We'll
husband,
see.
wife,
You have a child of how many years?
2 years, my lord.
And
my-
obviously, it goes the case, entire case against you only.
But my lord, also,
Child is 2 years, you got married in either 15 or
but
16 years.
my lord,
Section 6 is directly comes against you. Directly, not indirectly.
my lord has already come up with so many cases, my lord, in terms of Zian Singh and Narinder Singh, my lord also has so many others and position are not good. They are husband to wife and wife, my lord. Definitely it will be a use of process of the court, my lord. So by the way,
Yes, do you need this thing?
Lordship,
Do you need this record and all? I don't know. What is the case? Is the charge sheeted one?
charge sheet, my lord.
You got
my lord. Otherwise, my lord, there, my lord, the husband and wife, that is okay, my lord. But since, my lord, if we go by the, my lord, sections, my lord, section 6 is not compoundable, my lord.
No, not at all.
Not at all. That is what, my lord.
But my lord, in terms of my lord, in Shirazuddin,
One thing, we will see her statement and all everything.
Yes, then your lordship can
Ah.
decide, my lord.
We may call for the scan copy of the record and notice has to go. It is a POXO. This is a third person, fourth person, whoever may be. But you have
The-
made the party. This one, Pierre Ali, is the informant.
Informant has to start.
Pierre Ali could have been made a party here as a petition number 3. then matter would have been different, but he is here. And that part is a case of POXO 6.
But,
So we have to observe the formalities. We don't have
but, my lord, till then, my lord, the proceeding may be state, my lord.
POXO proceeding. Yes.
My lord,
POXO, we cannot, how can I fix?
my lord,
You
since-
text it today only, today or day after tomorrow. Okay, tomorrow, and text it.
otherwise,
What
my
to do
lord,
is a
the-
POXO case. I can
there is,
understand.
my lord will see the
The observations are there. I won't disagree with you.
possibility
There
of
are some
conviction, my
observations.
lord.
Pardon?
Since possibility of conviction is also not there.
Yes, obviously, but we have to observe the possibility because it's the case, section 6 POXO, no? Part Mr. A. Rahman, the learned counsel for the petition.
Proceeding, my lord, filed under section 138, my lord, NI Act, my lord, which is pending against me, my lord. And basically, my lord, on 2 grounds, my lord, because, my lord, this petition has been filed, my lord, impugn, my lord, complaint, my lord, for recovery of, my lord, 5 lakhs, my lord, amount, my lord, and that was filed, my lord, on 28/10/2020, my lord, complaint, my lord, 28/10/2022, sorry, my lord, and my lord, against one Me Infrastructure Private Limited Company and its director, my lord, and my lord, my lord, was at, my lord, earlier was one of the director, my lord, that I resigned from that company, my lord, on 23/5/2020, 2 years back from the closing of the affair, my lord. My resignation already has been accepted, my lord. I have connected both the, my lord. And another grounds, my lord, then this 5 lakhs was, my lord, given to the, my lord, this company, my lord, as a advance amount for purchasing a flat, my lord. And when, my lord, the flat was not purchased, then, my lord, that 5 lakhs was returned back through a check, my lord. And thereafter, my lord, that check was bounced. So, my lord, NI Act, my lord, case was, my lord, filed, my lord. Thereafter, my lord, this, my lord, complainant, my lord, again, my lord, subsequently filed title suit for specific performance, my lord, for having the flat again, my lord. So ultimately, my lord, together 2 proceedings cannot be go together, my lord, because by title suit they are claiming the flat, my lord, that we want flat, my lord, and by filing the, my lord, complaint case under 138 NI Act, my lord, they are saying that, my lord, we have to take back the money, my lord. So, my lord, both, my lord, cannot go together, my lord. So, and in, my lord, title suit, we have already filed, my lord, written statement. We are facing the, my lord, trial, my lord. So, my lord, I have now come for quashing of this complaint petition, my lord, that has been pending against me, my lord. Only one petitioner, my lord, and I, my lord, resigned on 20, my lord, 2 years back, my lord.
But money was given when?
My lord, money was given, my lord.
2021, I think.
Yes, my lord. Yes, my lord. That is my lord. So 2 grounds.
But there the director at that time.
My lord, at that time
You
I
were
was
very well there.
No.
At the 21.
Yes, my lord. But I resigned on 23. No, my lord. 2020, my lord.
2020.
Yes, my lord.
But he entered these things were happened on
After, my lord.
giving
After
money and all that
resignation of my side, my lord.
when 5 lakhs check was given.
My lord's
5 lakhs advance money was when it was given.
But after, my lord, resignation of
No. When?
But my lord, kindly turn to page, my lord, 13, my lord, complaint, my lord. Page 14, my lord, kindly. Relevant dates, my lord, for occurrence, my lord. Page 14 below, my lord. Relevant dates for 16/7/2021, 17/7/2021. All are, my lord, subsequent to my resignation, my lord.
Your resignation was accepted.
Yes,
when?
my lord.
When?
My lord, page 25, my lord.
Your resignation accepted.
Yes, my lord, page 25. And my lord, now they are, my lord, again, my lord, filing, my lord, title suit for having that flat, my lord. Against who is, my lord, they has, my lord, filed, my lord, complaint case, my lord, for recovery of their advance amount, my lord.
parties done in consequently. Then consequently petition and also card is MP to submit the learned petition every will be status. This is an application on section 528 BNSS for quashing the entire criminal proceeding being CR case number 6447 C of 2022 pending in the court of learned additional CGM farm of Guwahati. So how many accused persons are there? You
My
are
lord,
the one and one
four, my lord, including
Four.
my lord company, five,
five, no? Five accused persons.
my lord.
Swens. Show notice to the respondent. Registered 80 and educated process. Problem notice is required to the status of number one. However, copy of the petition be so during course. Next, hardly implemented. Next, this submitted by Mr. Sigler that representing this petition is no way in the office. It is the fact that he was one of the director in the company. Messrs, what the company?
My lord.
Name of the company? Amrit Residency.
Oh, yes, ma'am.
The company? No.
Name of the complainant, Tonu Singhi, ma'am.
Huh? Name of the company?
Company, Me Infrastructure Private Limited. Me Infrastructure Private Limited.
तो कॉलेज लिखे ना इबा infrastructure private. But on 23/05/2020, he gave his resignation and which is accordingly accepted by the company. But in spite of that, the present act has been lodged against the other accused persons, including the present petitioner, wherein it is alleged that ₹5 lakhs, which was returned through a check by the company, got bounced, and hence it further submitted that the complainant of this case also lodged and also instituted that suit for specific performance, which is also pending before the Planet Court below for trial. But the present petitioner is no way connected in the alleged offense, as he was not discharging his duty as a director at the relevant time, wherein the advance amount was paid as well as the checks in question was issued. Accordingly, he submitted that case for the present petitioner may be stayed till the disposal of the present petition. Considering the submission made by the counsel and considering the other matters in the record, the proceeding pending against the present proceeding pending before the learned court of additional CGM Commitment to Guwahati in CR case number 6447 of 2023 be stayed only in respect of the present petitioner till next date of list. List the matter accordingly after 4 weeks.
Highly obliged.
My lord, may I please the lordship, with regard to item number 8, my lord, when the matter was called for, I was in court number 25/4, my lord.
Sorry, cannot hear.
My lord, kindly my name may be appeared, my lord.
No, we are not doing the, it is absent. 15, yes.
May please, your lordship. Lordship, petitioner before your lordship is SLA order passed by the learned revision court, and before taking to your lordship to that order, I would like to take it to your order, your honor, to page number 22. Actually, lordship, the marriage between the parties was solemnized on 9/12/2019, and the wife, the respondent herein, has left the house of the petitioner on 29/4/21. Therefore, she preferred a petition under section 125 CRPC
And upon perusal of the evidences on record, the learned court below, learned trial court was pleased to reject her claim petition lordship. Your Honor will, your lordship will find the order at page 22. Yes. May I take your lordship to directly to the party portion? The order is a bit big. Page 61, lordship. From page 60, lordship. Last paragraph. It was written about section 125(4), lordship is aware. The next page, your Honor. Paragraph 36. In the result, the maintenance petition of the petitioner bearing MR number so and so hereby rejected under section 125(4) and disposed of accordingly on contest as the petitioner fails to prove that she has left the respondent husband her matrimonial home and refused to live with the respondent husband without giving any sufficient cause. It was, lordship, in my response submission, this order has been rightly passed after hearing all the parties, after taking evidences, the petitioner, the respondent herein, she has reduced 3 numbers of witnesses referred to the trial court, and as well as the husband, lordship, he has witnessed 4 numbers of witnesses. Being agreed by this order, lordship, the wife has preferred a revision before the additional sessions. Lordship will find the order at page 65. By this order, lordship, operative part, lordship will find at page 71. May I read the lordship? The order part, the revision is accordingly allowed. The impugned judgment ordered at so and so in influence is hereby set aside. The case is disposed of with a direction to the learned trial court for a limited purpose of defining the quantum of the maintenance payable to the petitioner, keeping in view the income of the husband, the economic condition of the petitioner, the standard of living she would have enjoyed in the matrimonial home. The learned trial court shall file a press order on quantum within a month of within a 1 month lawsuit. I am mainly assailing, lordship, this order, but the petitioner has not approached this honorable court immediately, for which the learned JFC has already passed an order directing the petitioner to pay in maintenance of rupees 10,000 to the wife. On the strength of the order passed by a session just. At best, lordship, at now my limited prayer is, lordship, that the order may be kept stayed, lordship, if lordship pleases, and at least, lordship, 50% of the maintenance amount and not the area amount at least, because the earlier the petition was rejected upon appreciation of evidences brought on record, and there is a divorce suit is pending before the district judge Dibrugarh between the parties. That is in the evidence stage, lordship, and if the area amount the petitioner has to pay, at present he is not in a position. I have annexed the medical documents and I am not pressing on this. Since you 120 petition, lordship, at least 50% of the maintenance he will pay, lordship, and not the area at present, lordship.
Children, do you have children?
No, lordship. There are certain allegations, lordship. I will not like to take your lordship to all those, because that is a issue which is to be heard in presence of the respondent, because I will place my submission, they will have to have counter submission. So I am not pressing on that, sir. But if lordship pleases to read the entire judgment passed by the learned JMC in order 19/7/24, whereby the 120% rejected, that was clearly stated everything. CF failed to prove, and there was a adultery on her part, admittedly. That was also proved, but sort of based on reasons of the session court has, since so 125 proceeding, maybe for that reason, I don't know, only to decide the quantum, and for that reason, the JMC has already passed the order directing the respondent to pay petitioner husband pay 10,000 lordship, which is a higher amount at this stage, lordship, and the area will be a burden on us, or a burden on me, lordship, because I have to look after my old age ailing parents, my uncles, and I am also taking care of my cousin who is a student, lordship. It was also on record.
State is formal here? No.
Sorry, lordship.
State is a formal party here? No.
No, lordship. In the revision also, state was not made a party, Lordship. Oh, sorry, Lordship, state was made a party.
Part Mr. S.N. Krishna Naitra, done it counsel for the petitioner. This is an application by Philip so and so connection with so and so against the imprint. Order dated 6/6/2025 passed by Honorable Learned Additional Session Judge Devu in criminal revision number 4, record 3 of whereby the judgment and order dated 19/7/2022 passed in MR case number 50 of 2021. It's set aside with a direction to the track court for determining the quantum of the maintenance. Issue notice to the registered area and visual process. Also call for the records of
Lordship, may I submit? I have also SL the order passed by the JMC, Lordship. That also SL. Page 73, Lordship.
order as it be done. And your 10,000 was passed on when?
On 15/7/25 at page 73, Lordship. The operative part at page 78.
Aranda also sent the order of 15/7/2025 passed by Learned Additional CGM. Whereby the petitioner is directed to pay monthly maintenance to the tune of rupees 10,000. It is submitted by Mr. Krishna Atra that the issue notice submitted by Mr. Krishna Atra that the present petitioner, the respondent as a first party initially lodged an case under section 125 CRPC. But after but the safe case, the learned trial court below rejected the order of prepare for maintenance under section 125(4) CRPC to and the ascending date order. She preferred an revision petition before additional session judge Dipupa, which is numbered as criminal revision number 24, record 3 of 2024. 24, full stop. And after hearing the matter, the learned additional session judge had set aside the order of learned trial court below and passed and directed the learned trial court below to decide the quantum of the maintenance allowance, considering all aspects of the case, and accordingly, the learned trial court below, in pursuant to the order of the learned additional session judge, had passed the order on 15/7/2025, directing the petitioner pay rupees 10,000 per month, though initially the prayer for maintenance was rejected on the basis of evidence adduced by the parties. He further submitted that the petitioner is not in a position to pay the arrear amount and the maintenance amount of rupees 10,000 per month, as he has the burden of whose burden you have?
Lordship, my old age ailing parents, my uncles, and my cousin.
Uncle, cousin?
Yes, yeah, my uncle and auntie, and my own cousin. Because my uncle is not an earning person. I have to bear all the expenses. That is on record, Lordship.
Oh, you will bear the uncle auntie's expenses and you're not going to bear your
No,
wife
no, I am fairly submitting, Lordship. She is not entitled for maintenance only, but I am ready to pay 50% of the maintenance amount, Lordship.
Has the burden of his co-ailing parents as well as his.
Yes, I was ready to take her back, but she's not willing to come back.
Other family members. However, he submitted that he may be, he is still ready to pay 50% of the amount. Expert considering this submission made by land council for both sides. Petitioner hereby directed to pay rupees 6,000 per month daily disposal of the present petition. And till next date of listing, area amount be payment of the area amount be state, okay, state. Till next date. This is the matter according after. You're going to pay 6,000 per month.
Yes. And area amount
Area amount be state.
Deeply obliged, Lordship. May it please your Lordship. Lord, this revision petition is basically against the, my lord, passing of an FIR. Before going to the FIR, my lord, I'll place the fact of the case, my lord. The petitioner purchases a plot of land from opposite party number 2 by a registered sale deed. And your Lordship kindly, my lord, directly goes to, my lord, page number 62. Page number 62, my lord. This is a agreement for sale, my lord. Page 62, my lord. This is a agreement for sale between, my lord, opposite party number 2 and the petitioner, my lord. That is the agreement for sale. That is also registered, my lord. And my lord, your Lordship kindly see, and after observing all formalities, that is, his son is, my lord, the witness number 1, and another Dibbojyoti Gogoi also one of the witness, my lord. And your Lordship kindly see page 66, my lord, and the photograph, thumb impressions, everything is there along with, my lord, witnesses, my lord. Then, my lord, certificate of registration was issued, that is in 67. So that was, my lord, agreement for sale, my lord. Thereafter, money has been paid, and then, my lord, formal agreement for sale was registered. That is, my lord, page 70, my lord. Page 70, my lord. Page 70, my lord. Nowadays, my lord, after obtaining permission, my lord, you have to put the photograph, and, my lord,
It's 70 healthy.
70 is the sale deed, and that is registered, and the same witnesses are there, and their certificate of registration also given to me, and, my lord, time and everything. Nowadays, photograph and video recording also, I think some of the cases, my lord, video is there, my lord. Now it is, my lord. So after getting permission. So after that, my lord, after sale is completed, I took the possession of the land. So on 3/3, my lord.
Who took the possession? You.
My lord. I took possession. I gathered building material, and I tried to start my construction. Then, my lord, opposite party number 2, along with his daughter, my lord, when they stopped me that you cannot construct in that, my lord, because that was the land because of her daughter, my lord, his daughter, my lord. So his daughter claimed that it was supposed to given to me. So that's why they have stuck me and they have detained me to kill, my lord. So immediately I went to the police station, I lodged an FIR. That is, my lord, annexer. My lord, that is annexer, my lord, page 27, my lord. Annexer 2, page 27, my lord. So, page 27, mechanical is page 29, my lord. That is সন্মানপূৰ্বক বিনীত নিবেদন এই যে মই তেজপুৰ চহৰ 1 নং চৰকাৰ সুৰেঞ্চৰ কুমাৰৰ পৰা ক্ৰয় কৰিছিলোঁ যোৱা 27 নৱেম্বৰ 24 তাৰিখে সম্পূৰ্ণ বিক্ৰী নিয়ম অনুসাৰে মাটিখিনি ক্ৰয় কৰিছিলোঁ। মাটিখিনি কতবাৰ হৈ নতুন দাগ নামৰ পটা নামৰ ওপৰত দিয়া হৈছে। ক্ৰয় কৰা মাটিখিনি জমাবন্দী খাজানা ৰচিদ অন্যান্য প্ৰয়োজনীয় নথিপত্ৰ সকলো মোৰ লগত আছে। বেচা কিনাৰ বেচোতাৰ পুত্ৰ শ্ৰী অনুপম বৰা সাক্ষী হিচাপে আছিল। কিন্তু আজি 3/3/2025 তাৰিখে উক্ত মাটিত ডোখৰত ঘৰ বনোৱা যাৰ কৰাত মাটিখন পূৰ্বৰ গৰাকী ফণীন্দ্ৰ কুমাৰ বৰা আৰু তেওঁৰ ছোৱালীয়ে উক্ত মাটিত মোক ঘৰ বনোৱাত বাধা প্ৰদান কৰি মোক গালি গালাজ তথা পানে মৰাৰ ভাবুকি খেদি পঠিয়ায়। গতিকে পদকীয়াকৰণে কোনো উক্ত মাটিখিনি সম্পূৰ্ণ নিৰাপত্তাভাৱে নীতিগতভাৱে বিক্ৰী দিয়াৰ পাছতো তেওঁ উক্ত মাটি ঘৰ বনোৱাত বাধা প্ৰদান কৰি ষড়যন্ত্ৰমূলকভাৱে মোৰ লগত ঠগ প্ৰবঞ্চনা কৰে। গতিকে পদকীয়াৰ বিৰুদ্ধে আইনগত ব্যৱস্থা গ্ৰহণ কৰাৰ বাবে প্ৰদান কৰিলোঁ। Accordingly, my lord, case is registered under Tezpur PS case number 148 of 25 under section 318, 316, 297, 351, so and so, so and so. So this case was registered, my lord. So as a counter to this, my lord, very next day, my lord, the opposite party number 2, who sold him, who has been the sale, my lord, who has given done the sale deed, my lord, he lodged an FIR against me, my lord. That is annexure 1, my lord, page 20, my lord. Vernacular portion is page 22, my lord. So now, my lord, basically I am against this FIR, my lord, and this FIR is, my lord, out and out. That is actually, my lord, that FIR is also lost against his son, my lord. Son is also, my lord, one of the accused. He getting a bail, my lord, and this honorable court giving a, my lord, findings that, my lord, is out and out civil dispute. So the son was granted, his son was granted bail, my lord. And not only that, my lord, already, my lord, for cancellation of bail, cancellation of the sale deed, my lord, and title suit was already, civil suit was instituted. I filed my WS also, my lord. So that is the background of the case, my lord. Now, my lord, your lordship kindly see in this FIR, my lord, which was, my lord, counter to after filing my FIR, my lord, this FIR was lost. It's clearly attacked the, my lord, clause 7 of the Bhajan Last cases, my lord. So that is why I am before your lordship, my lord. This is the case, my lord. Because in the FIR does not disclose, my lord, any offense, my lord, and that is absolutely a concocted story, and that is just to counter my case, my lord. After filing registration of my case, my lord, this is registered. And my lord, your lordship kindly see, my lord, the bail order, which was, my lord, his son, he appeals this honorable court, and this, my lord, bail was granted by this honorable court. Bail order question. Page 33, my lord, your lordship kindly see. Page 33, my lord. There's Anupam Bora. He has taken bail, my lord. He is the son of the opposite party number 2. Page 34, my lord. I have considered a submission made by the learned counsel of the both sides. On plain reading of the FIR and the document available record, it appears that it is a civil dispute between the parties. Informant has other forum to seek the justice. So on, my lord, that count, my lord, I before your lordship, my lord, if this, my lord, and this FIR is allowed to continue, there is nothing, my lord, is a abuse process, my lord. So my submission before your lordship can issue notice, my lord, let them appear before this honorable court, and in the meantime, my lord, I may be protected.
Yes, but there is already a civil suit pending, my lord, regarding the authenticity of the sale deed, my lord. So
The authenticity of this
sale deed, my lord, what complainant, what opposite party is claiming that by fraudulently they took the signatures, my lord, by his son and the petitioner, my lord.
What?
But whether that will
That
be
has to be
decided on
decided by civil.
will decided on the civil court, my lord. Otherwise, it can also.
Obviously, civil suit is there.
There.
Now, but this case is.
Civil suit, I mean, claim,
This,
I have an
this case is regarding the FIR, my lord. If your lordship find page 19 is the FIR, my lord, where it says that the land given to complainant's daughter was very tactfully and skillfully sold by the complainant's son, Sri Anupam Bora, my lord.
Actually, daughter claimed it, my lord, that that portion has, that land was supposed to keep from me. What my another brother, my lord, sold. That is a clash between brother and sister, my lord. But my lord, why should I victim, my lord? Why the criminal liability? I mean, they are dispute, my lord. Because maybe, my lord, his portion has been sold to me, my lord. And my lord, father went to the registration office, give thumb impression, photograph, everything. Nowadays, not only photograph, my lord, thumb impression is also required. That I have given, my lord. And time and everything is recorded.
Now at present.
Now, my lord, it is very difficult.
Everything is
Dear my lord. So I have an extra.
Though he challenged that you fraudulent.
So my lord, actually I am victim of their part.
Again, my lord, a geotagging is also required. Photograph of
Yes, my lord.
that is also required before the land which has to be sold.
Yes. Now it is so that has.
That is also.
So that everything, my lord, I have annexed, my lord. And nowadays, after the getting registration, immediately certification issued by the authority. That is, my lord, uploaded, my lord. That certificate also, my lord, I have annexed, my lord. Now, my lord, because of their family dispute, my lord, I am unable to even construct the house, my lord, and my lord, police is also, my lord, that the case is pending, my lord. Police case is pending. And my FIR also registered, my lord, then there is a proceeding against them also going on, my lord.
Mr. TJ Ilan Senior assisted by
Petitions.
assisted by Mr. Ambition Ilan Consultative and also heard Mr. MP Goswami Ilan Election PPA. It's an application sections. Issue today response to register daily and formal offices with police. Of the petition is taken during the course of it's right submitted by Mr. Mohammed. Petitioner is himself. List agreement for sale was between petitioner and the respond number two. Respond number two proposed to sell. And thereafter, after observing all the necessary formalities, the certificate was also issued. And then the final sale deed was also executed. Executed by the petitioner number opposite party number two. But when the petitioner started started depositing some materials for construction, the opposite party number two had and asked to stop for construction work and also threatened with dire consequences, and for which the petitioner also had to lodge an FIR before Tizpur police station, which is accordingly registered. Soon after the registration of the said FIR, the present case has been lodged by the respondent number two with some possible of allegation against him and his against the petitioner and his own son, who stood as a witness to the sale agreement as well. Mr. Mohammed further submitted that cannot be any impersonation, etc., as alleged by the FIR, as the petitioner himself, respond number two, himself went to the concerned office and put his thumb also annexed. Submitted that the CD for and the petitioner next one. Mr. Goswami, the learned additional people submitted in this that it's the fact that there is a civil cases also pending before the court of civil forum, and however, he submitted that there are some implementing materials brought in the FIR against the present petitioner. Accordingly, he insisted during this submission, let the CDB and in the next step of listing, because petitioner may be protected and no corrosive action shall be taken. When it can be listed, Gusam?
So need more, madam. After 3 weeks.
After 3 weeks. You need a date because CD we are calling for the CD.
Yes, madam.
After
We
3
have
weeks.
called, madam, but yeah. 3 weeks, any date.
18 দিন 26 নিদি
after Puja.
after Puja. Oh, people.
After Puja vacation.
After Puja.
After.
Then it will be after Puja, not
No.
26. Yeah, not
No.
good. After Puja vacation, people. No, after Puja. Fourteenth October. 14th of October.
My lord,
You'll
in
be
the
some
meantime, my lord,
provided with some interim protection.
interim protection, my lord. Yes, fine. That further proceeding of the debt 149 of the ES case may be stayed.
No stay. Stay, that's why I'm just asking you, because it is a case we cannot stay. But no coercive action shall be taken, you are protected, that much only.
No,
So if
my
you
lord,
want to prepone the date, then yes, okay.
No, my lord, coercive protection, my lord, already, my lord, that stage has gone. I was arrested and granted bail. So
Oh, already
stage-
granted
oh,
bail.
already granted bail, my lord. Because my,
Oh, then to we further stay of the inquiry to be not in a
no, my
position.
lord, it is
Then in that case, we
absolutely,
are going to fix a short date. Very short date.
otherwise, my lord, coercive protection, that stage is nothing, my lord.
That's
not-
also, okay, then I thought otherwise.
My lord.
In that case, we are giving a very short date to you,
My
so
lord.
that CD can be perused. Because it's a quashing proceeding, and then
Yes,
the
no,
question
because
is that
it
we
is,
cannot stay the investigation.
if your lordship go by the content of the bala anadhikar probek, my lord, this was my sole land, I got the possession. How can I, my lord, unauthorized the FIR?
That is
So that's why, my lord, I am submitting is out and out, my lord, counter to my FIR, my lord. Because I file a FIR because they have given me obstruction, my lord.
CD call for short date. Or maybe or more shorter,
short
more short, 10, 11. Within 10, 11, there
Yes.
will not much progress in the investigation. 11th of September.
And then, my lord, your lordship kindly on the pair of interim, my lord, your lordship kindly issue notice, my lord.
Pardon?
Then, my lord, your lordship kindly on the my pair of interim pair, my lord, your lordship kindly issue notice, my lord. Yeah, interim will be considered after receiving the case. Because
Notice on
No,
same pair.
Notice on?
Notice
stay
on-
on, notice on interim pair, my lord. Because I have a pair interim pair for further proceeding will be stayed of the, my lord, that proceeding, my lord, FIR, my lord. So if
That's
your
what
lord,
I'm saying. I thought that you are not on in any bail
my
and
lord.
all. That's now you are clarified. That's why we are giving a date on 11th.
Yes.
If CD reserve. That's why we are listing it on 11th, so that we can dispose of the matter. If a quashing is required and quashing entire matter will be quashed.
My lord.
That's why we are fixing it on 10th, or can it be on 10th? Then 11 BCS. 10. Let it be on 10th. By 10 itself, we are going to dispose.
Then, my lord, your lordship kindly call for the scan copy of the.
Scan copy of CD.
Yes. We're
My-
calling the scan copy. That's what I'm saying. In the meantime, you take notice,
No, my lord.
issue notice also.
Deploy.
And suppose if the other side doesn't appear, or if they seek any time, then definitely we'll pass an order.
My lord.
of entry.
May it please your lordship. There is a quashing petition seeking quashment of a charge sheet, my lord. Allegations are of 498A and section 4 of the Dowry Act, my lord. My lord, may I draw your lordship's attention to the FIR first? But the FIR is at page 61.
60.
It's a long FIR. I will not bother reading the entire FIR. I'll just draw your lordship's attention to the basic. First, my lord, at 61, last line. I'm the husband. My wife has lost the FIR. The last line on page 61. All the wedding arrangement expenses were borne by my family and not a single penny was paid by my husband. This is the allegation 1. In second, my lord, in the second 62, second paragraph, the line goes, after cohabiting together as husband and wife for a few days in my matrimonial home, my husband shifted to Poland on so-and-so for his work, leaving me behind. And after kindly note this, after single-handedly working out the visa formalities, I shifted to Poland to stay with my husband. This is the allegation number 2. It is pertinent to state that herein that all the expenses for traveling to Poland was borne by my father. This is allegation 3. My lord, in the last line on the same page, soon thereafter, the situation turned from bad to worse. My husband started physically harassing me by slapping me, kicking me, and choking me with his hands. He started demanding, now the fourth allegation, he started demanding dowry from me, but at the same time acted innocent in front of my parents. To satisfy his illegal demands, I used to call my parents in Jorhat and beg them for meeting my husband's dowry demand. Although belonging from a middle class family, my father, for the sake of his daughter's happiness, transferred an amount of rupees 8 lakhs during a short interval of time to my husband's account. Then, my lord, below you will see, my lord, he started physically assaulting me on regular basis. Then on the same page, down below, my lord, last line, I informed my mother with regard to my husband's illegal demands. As I stayed alone in an alien country with no friends and family, I had no one to seek consolation. Whenever I complained, said facts to my parents, they used to ask me to be patient, saying that things would be eventually better. Then, my lord, page 65. Page 65, the last, second paragraph. Further, my husband has also illegally confiscated my belongings, such as so and so, so and so, so and so. My resident permit issued by the government of Poland has also been stolen by my husband. This is the last allegation. Now, my lord, may I draw your lordship's attention to page 29. My lord, kindly note the FIR is dated 22/2023, the FIR. This is the divorce petition which I 22, 20th of February 2023. Now this is page 29. Has your lordship got it?
Yes.
Page 29. You know, this is a divorce petition which I filed against my wife on the grounds of cruelty. The date is important, my lord, 6th of January 2023. After she receives the notice, she files the FIR. My lord, may turn to page 21 first. 21. There are certain documents which I would like to demonstrate that each allegations are false and concocted and baseless. 29, 28. 28, this is an email written by my wife to me. It's a long email. This email where she apologizes for her erratic behavior against me and for her embarrassing situation which she created in front of my friends. This is the email given by her to me. Then, your lordship, may kindly come to page 78. Page 78. As your lordship will remember, the first allegation was that I had not paid a single penny for the wedding. So this is a receipt, which clearly shows that it is me who had paid. Then allegation number 2 was that I never helped her with her visa. So, my lord, page 79. Page 79. She applies for her visa, and these are the conversations between me and my wife, wherein I am telling her how to apply for the visa. Page 80. Where I was in Poland, she was here. I was helping her. Your lordship may kindly peruse page 80. These are the conversations between me and my wife. I am helping her with the visa application. Then, my lord, 81. It's a long one. I will not read out, but your lordship may read it. She writing in to me. I will not read out in the open court, my lord. This is page 81. Your lordship may read it. She is writing to me. Her name is Pickley. It's about. It's her nickname. Page. The greens are me writing and the white are hers.
Okay.
Lordship got it? Second allegation was her mother, she complained to her mother that I am of a bad character. Now, Lordship may kindly turn to page 84.
80.
84. These are the conversations between me and her mother. Her mother is writing to me. Your Lordship, I will not read in the open court. Your Lordship may read it.
Okay, then these are the things
Yes.
of conversation.
My Lord, then the last allegation that I had demanded dowry. My Lord, kindly bear with me, page 91. And she said that her father had given me money because of my demand. This is 91. Her father writing to me. Wherein I clearly stated that I do not want a single penny. However, it was given to me as a gift. Yes. And this is after she went to Poland after her marriage.
What she said.
Yeah.
You said that she should be demanded. It is matter.
I'll bother Lordship with the last document, the last page, page 100. She had stated that I had kept all her documents and especially the resident permit. She had taken back all.
These are received.
She had received. These are all afterthought, nothing baseless. She came, she took everything she has received. She signed. And the same day, when she received, Lordship sees down below page 100, when she received 20th of February 2023, after receiving, she files the FIR against me. Each and every allegations are baseless and concocted, my lord. And everything springs into life after I file and divorce petition on ground of cruelty. Now a charge sheet has been filed against me. When these documents clearly demonstrates, then why should I even for one day stand in the character of an accused in the trial court, my lord? At this stage, my lord, I am only praying that a notice may be issued to the private respondent, my lord. Until then, this criminal proceedings should be kept at abeyance.
Yes, who is appearing here?
Is it?
Seems to be. The case has already been charged.
At this stage, notice should go to the respondent number 2.
Respondent.
J-board. J-board. And also heard Mr. Possibly learned additional people depending on the said respondent. It's an application and section connection. And issue notice to the respondents to register it as usual process. The formal notice is required to be served on state respondent. And per copy of the petition may be served during the course of the day. Pardon the interim report. It is submitted by Mr. Borak that the present the FIR has been lodged with some faults in the petition. Only after instituting a divorce petition by the present petitioner on 6/01. After receiving the notice of the divorce petition, the respondent also came in and she took all the documents, including the residence certificate, etc., from the possession of the petition, and to that effect, he also issued also received also issued a also issued a receipt in that. But in spite of receiving all the documents, it is alleged that the documents are in still possession. And apart from that, from all the materials and the exhibits, it shows that all false and purported allegation, like demand of dowry and the behavior with parents of the respondent number 2, etc., are being brought only to harass the present petition. Only to harass the present petition. But the case has already been charged and the cognizance has been taken.
Cognizance has been taken.
Cognizance has already been taken against the petition. However, considering these aspects of the case, the proceeding against the present petitioner may be stayed till the disposal of the present petition. You were the only accused in the
I'm the
case?
only accused, only. Sorry.
Mr. Kaushik, you done it submitted in this that second copy of the case record may be called for the fact of the case. However, considering the submission made by Mr. Gomez, all the annexures filed along with the petition and other aspects of the case, the further proceeding in respect of the present petition, we state till next date of pending report of learned GMFC number 3, M. We state till next date of listing in connection with PRC case number 795 of the list the matter according to it will be listed. You take steps on the respondent number. We are also calling for the scan copy of the DCI.
Ma'am, DPO. Yes.
This appeal stands allowed and the judgment and order passed by the learned session judge Jorhat in sessions case number 85, 2007 is the other citizen and quashed and the accused appellant is set at liberty.
Mobilized, Lordship.
May it please your lordship. My lord, this petitioner against the impugn order, lordship will find page 30. May I read, my lord? Case record is put up before me. Today is
Case number 13 or 30. 30.
Case record is put up before me. Today is fixed for submission of report. Accordingly, the IO has submitted the report.
The IO in his report has stated that account number so-and-so has been freezed as online complaint has been registered on cybercrime platform by one Babusana Sinha from Jamnagar by the acknowledgement number so-and-so. Heard both the sides. In view of the report of the IO, the prayer in petition number so-and-so is rejected. My lord, what happened in this case, my lord? The petitioner is a government employee already retired. While he is coming from Silchar at Guwahati, while getting down from the train, his mobile phone was stolen by someone. My lord. So immediately he filed a complaint before the GRPF railway, and thereafter, my lord, he obtained a duplicate SIM card. After obtaining the duplicate SIM card, he has seen that from his account, some person is some money is debiting.
Money?
Money, yes, madam. Someone has debited money. So immediately he submitted complaint before the concerned police, my lord, and also bank. Accordingly, my lord, bank blocked his account, my lord. Thereafter, my lord, since his account is connected with his, my lord, pension account, my lord, so he again submitted an application for, my lord, this unfreeze of the account, my lord. Then, my lord, bank is not willing to unfreeze it unless an order from the court, my lord. He approached the Chief Judicial Magistrate, my lord, and filed an application, madam. Lordship, may kindly see the application is page 26. Stating all details, my lord, he submitted an application before the London Chief Judicial Magistrate, Qatar Silchar. Prayer is, my lord, in second, most humbly prayed that your honor would be graciously pleased to call for a report from Silchar PS, and after perusal of same, pass order to the concerned bank to release the lien amount to the petitioner and also unfreeze the account of the petitioner by police by bank authority. So after submission of this application, the learned Malad CGM called for a report. That report is page 21, 28, and except 6. So report stated, my lord, with reference to the subject cited above, I am the honor to report you that on perusing the record of PS number, such record found lodging of complaint petition against cybercrime by Altaf Hussain Laskar. Further, it is pertinent to mention here that while checking the account number so-and-so given in the order sheet.
Which page?
Page 28.
28, Lordship, Annexure 6.
Annexure 6.
Yes.
May I read from? With reference to the subject cited above, I have the honor to report you that on perusing the record of PS number, such records found lodging of complaint petition against cybercrime by Altaf Hussain Laskar. This name has been written wrongly, madam. Altaf Khan. Further, it is pertinent to mention here that while checking the account number given in the order sheet, it is revealed that the said account has been freezed as online complaint has been registered on cybercrime platform by one Basu Sana Sinha from Jamnagar by the acknowledgement number so-and-so, submitted for favor of. So on the basis of this report, Chief Judicial Magistrate has passed the appeal order. So my case is that, my lord, since the cause of action is here, my lord, because my mobile phone is lost here, my lord, I submitted the complaint before the concerned police, my lord, and concerned police also submitted the report, my lord. But still, my lord, Chief Judicial Magistrate has passed the order without assigning any reason, my lord, why. But from the, my lord, order, it's suggested because of that, my lord, because the complaint is received from, my lord, outside, my lord. From Jayanagar, my lord, this is, my lord. So, my lord, this is not correct because, my lord, Lordship may kindly see, I have annexed, my lord, annexed our High Court some guideline, my lord, Lordship will find in the case of, my lord, 34, page 34, my lord. When there is the case of such, my lord, cyber-related crime, concerned magistrate has to, my lord, pass after collecting the report, he has to pass order, my lord. Lordship may kindly see page 34. Last. Annex 9.
What is in the?
It's a very peculiar case, my lord.
My lord, I have
No,
submitted
notification
online.
is- Notification here is all right.
The notification is there.
Because obviously notification will be there because these things, it is directed not to register the case because online on the online.
Yeah,
complaint,
online for
the cybercrime has already.
I have
registration.
submitted.
So that's why case is not registered. Your prayer for defreezing your account has been rejected only.
Yes, ma'am.
this is for purpose of my lord referring CS annex my lord.
FIR which one? FIR?
No, for the purpose of my lord referring to that no FIR has been.
Yes.
that is-
Yes, my lord. There is no FIR, only GD&T is there, my lord. GD&T is there, my lord. No FIR, but he has to pass order, my lord, because my lord, my pension account is the only livelihood of my pension, and this amount has been already, my lord.
But then, do you have any answer on the basis of what there was some online complaint against
Yes,
your
ma'am. I have
transaction,
submitted the online
account.
complaint, but they
transaction,
have
there
not.
is some online complaint is there.
Yes, I submitted.
So
ma'am.
then,
There is
that
no
is- that is-
response from that part. I have, that's why I made a party of them also, ma'am.
yes.
My lord, yes, a complaint is there. That is why what is the complaint? Nothing of sort, my lord. The IO's report also is very simple, my lord, that the complaint has been registered. So accordingly, please, my lord.
My lord.
Now, my lord, what is his, my lord, complications, my lord? Why it is being frozen? So,
My lord,
how can you say, my lord? Nothing.
this
my
is the only
lord,
basis,
report.
my lord, what happened? My lord, lost to
He
my
said
kindly
the
see.
on the basis of his most probably complaint, it was freeze.
It was
No, my
free.
lord, some amount of money credited again in my account. And this is lost to my kindly see. I have this bank account, my lord, page 14 onwards, lost.
After his mobile has been stolen, my lord.
Yes, my lord.
And thereafter, some amount has been first credited to his account, my lord.
No,
And
first,
thereafter-
my lord, debited,
No,
and
as
thereafter.
as per your complaint, it is first credited, then again withdrawn, my lord.
Then
No.
again, credited.
No, my lord,
Yes,
after loss
yes,
of my
please.
mobile, first some money debited from my account, my lord.
But it,
And
page
thereafter.
27, my lord, it is there.
Page?
Page 27, it says, my lord,
Hmm.
page 27, my lord, the paragraph last line, my lord. It is here to be mentioned that miscreants deposited an amount of rupees 10,000 and 20,000 on such and subsequently withdraw the same.
Yes, my lord. I have stated on bank account, my lord, I lost page 15 lost. Before that, some amount debited from my account.
And
So, my lord, my case is that even a lordship may, my lord, lien this amount, 10,000 and subsequent 20,000, my lord, credited in my account. Even if keeping a lien of this amount, my account may be, my lord, unfreeze, my lord, because I have, due to this, I am.
No, but at present to against your account, there is a complaint.
My lord,
It is registered
subsequent
as a cyber complaint.
Yes, after loss of my mobile, my lord.
Or whatever,
After-
against your account,
Yes.
one cyber crime is there already.
Yes, lord.
Registered.
Yes.
So how can we,
My lord,
those
in a re-
are your submission that you have lost your mobile, you have made a complaint, these are
No, my
things.
lord, I submitted all
But the
documents.
question
my
is
lord.
that some amount was credited, then debited or whatever.
Yes.
But on the basis of this, some complaint, there was some complaint from some corner most probably. And that's why the cybercrime case has already been registered in Jamnagar.
Yes,
Yeah.
that's why, my lord,
So how can you?
our High Court, my lord, in a
Freezing on.
read jurisdiction, my lord, since I approached the CGM, that's why I am coming in the inherent power, my lord. In our High Court, my lord, in
No,
similar
they
type of,
have the jurisdiction.
yes.
For registering a cyber crime, they have the
No,
jurisdiction.
they have
because these
jurisdiction,
are
but this
transactions.
court has also jurisdiction, my lord.
What for?
My lord, to direct to unfreeze the account, my lord.
Your
Lordship,
account
I
will
have
be there.
given order.
Whatever. Yes, Goswami, what to do?
at least we have to at least
Lordship,
pray for
issue
my lord,
notice.
fee, my lord, regarding a press report, my lord. At least what is the case, my lord, that has not been diverse from the petition, my
What
lord.
is the case in fact?
Yes, what is the case against
So,
him, my lord? And
may,
what is the locus of the informant who had that person, my lord? nothing is there, my lord.
Yes,
So
sir. Yeah, from here we have nothing.
we cannot,
Because he has not enacted the original complaint.
Original complaint
On
is
the
not
basis
there.
of where which the,
Yes.
this,
what is the
cyber
complaint
cyber
against
this is
him?
registered.
Nothing is there.
Yes, from the report, it says that one Babusana Singha made a complaint.
But
That's
somewhere,
why-
somewhere possibly he may also be shown as an accused also.
Yes.
Because the complaint is against his account number.
Against his account.
That's why.
So, my lord,
they-
I have
please,
annexed
if
the
we-
document.
Yes, but if you do
It's
not
not a
find it,
case.
yes.
Lordship, may kindly
He
see
made the-
page 12 is the FIR which was I lost on 12, my lord,
It's
14.
Your case you have lost.
A press report may be confirmed, otherwise.
Report, but this kind of report will not help us.
This will not help.
Lordship may issue short notice.
And next week, short notice to whom?
My lord, my lord, I have made party, this the Director General of Cyber Cell, my lord. That is my lord Gandhinagar, Gujarat, and Superintendent of Police Officer, SI Gujarat, Jamnagar.
So there are as many as, including state, there are 5 respondents.
Yes.
To issue notice, and in the meantime, from where you are going to,
This is my officer in charge.
no, officer in
Silchar
charge will
Kachar.
be able, Mr. Goswami to.
My lord,
Officer in charge, Silchar Police, my lord.
first, my lord, from where this complaint has been lost, my lord, that is also not clear.
My lord, this complaint has come to respondent number 2.
Simply mention that it has been most probably in Jamnagar, or.
This police, my lord, our police mentioned it. Our respondent number 2 mentioned, my lord.
If applicant has this, yes, copy of state cyber.
And
site
bank also stated, my lord. Lordship may kindly see, bank has given a note in this regard, my lord.
They have made one for the Director General of Police.
Yeah,
State cyber. State cyber can be,
They are the authority, my lord.
they
I-
can be, asked to provide the detailed report or otherwise from where report. Because officer in charge,
where-
police station, they have nothing with them.
They have nothing, and they, perhaps they have not reached the account, my lord.
No, but they have his, my lord.
Huh? Police.
Silchar Police.
No,
Silchar-
not police.
My
Silchar
lord,
police
a
station
email-
has freezed your account.
No, email come from the, my lord, Gandhinagar, my lord.
Where from?
Gandhinagar, Gujarat, my lord. From the cyber, my
On
lord.
the basis of that email.
Yes, man. On the basis of
And
that
but
email.
you have submitted earlier that you made a complaint before the bank also that some transactions are there.
Yes.
On the basis of your complaint, it was.
No,
freezed.
no,
No.
madam. On the basis of that complaint, my account has been freezed.
The complaint has been where from it?
It is
Gujarat.
Gandhinagar.
Gandhinagar, Gujarat.
Gandhinagar.
If, my lord, then, if the freezing has been done by, my lord, the.
It is done by our police on the instruction of my.
From the Silchar, my lord, then let.
No, both 2 and 4.
Yes, there the notice has to go, my lord. 2 and, yes. 2, my officer in charge.
2 is the officer in charge.
And yes.
And 4 is the Director General of Police.
Yes, and
Yeah,
5,
PID.
yes.
Cybercrime.
And 5 and 6, my lord, notice has to go, man. Gujarat.
No. You are
Bank-
going to represent someone.
Yes, 1 and 2, my lord.
You are going to represent 1 and 2.
2, my lord.
3 is to bank.
Bank.
3 is a bank.
Notice may also
4,
go, my lord.
4 you are not going to represent.
No, man.
Then
1, 2, 3, 4 couldn't.
1, 3.
Go to Gandhinagar.
No. 3 is internet.
4, 4, 5.
Whereas, my lord, 1, 2, 3, 4, 5.
3, how can you represent 3?
No, we cannot represent that.
3 may notice may go, my lord.
You can only represent 1 and 2, I think.
1
Yes.
and 2, man.
1 and 2.
There is a wrong in the, my lord, serial number, my
I
lord.
had to correction also.
That's it, huh? Then it will be 4 and
4
5.
and 5.
4 and
Yes, 4 and 5. 3, 4 and
1 and 2 we can get.
3, 4 and 5 may not notice me.
five. You have Mr. G. Uddin,
Yes.
Hard Mr. G. Uddin, and also Hard Mr. And so, Swami did on it for mediation. Section 5, legal section and BNSS for washing the income order with 5 feet past in connection with seizure is GDE number 54 of it 25 CGM Kachar seizure detecting the prayer for refusing the account of the presentation. Issue notice to the to all the response to registered AD and registered process. No formal notice is required to serve on response number 1 and 2 as state is representing both 1 and 2. However, copy of the petition may be submitted. What's the petition respondent number 2 and 4 are also hereby directed to give a detailed report in regards to registration of the cybercrime as well as the freezing of the account of the bank account of the present petition. Of your SBI bank account, State Bank of this is the matter accordingly. It may take some time. I think let it be 3 weeks or 4 weeks.
My lord, because my lord, pension amount is my lord credited in his account, but he is not getting it now.
Pension.
Yes. Sir.
But it
Some
has
short
to
date,
come,
my lord.
because short date will not serve your purpose.
No.
Uda, it will
Three
again
weeks,
delay your process.
3 weeks.
15 minor.
3 weeks. We'll see it
3
after 3 weeks. List after 3 weeks.
My lord, one
Let
observation.
them appear then from we don't have anything. Do you want any CD and all? We don't have anything.
No.
Simply their presence may be required and we'll hear to matter. They,
Yes.
after their presence, they may file for something, then we'll see.
Yes, madam.
Otherwise, what to call for? We have
Yes.
nothing.
And
Only
madam, a report can be called for madam, regarding the GD entry number 5425 from the IO madam.
Yes.
For
that has
status.
already been called for.
That
From
is-
item number, your response number 2 as well as response number 4.
Yes.
We have called.
Call.
Yes.
After 3 weeks, we'll do.
Well, one observation may be, my lord. Pendency may not be barred, my lord. Please,
For?
pendency of this petition may not bar to unfreeze his account.
For?
Pendency of this petition may not bar.
May not bar for who?
Bar to unfreeze his account, my lord. If they want to do, but sometimes, my lord, due to pendency, they are not doing, my lord.
That's problem.
Slightly for that.
Observation.
May it please your lordship, the petitioner herein has challenged the complaint petition pending before the court of the learned judicial magistrate first class, Sibsagar lordship. In this case, what has happened, lordship? The other respondents of the said complaint petition has already approached this honorable court, and this honorable court by order dated state the said proceeding, your lordship. Complaint petition is at page 22, your lordship. Page 13, your lordship. It starts from page 13, lordship. And page 14 is the name of the accused persons, lordship. So 1, 2, 3, and 5 had already approached this honorable court, lordship, and this honorable court state the said proceeding, lordship. So at this stage, lordship, this matter may be taken along with the said matter, lordship. The petitioner is the accused number 4 in the said complaint petition.
So what do you want?
Lordship, this matter may be listed along with the matter, lordship, because the complaint petition already stated by this honorable court, lordship, there are four respondents in the said complaint petition, Lordship. 5 respondents, Lordship. 4 had already approached this honorable court or filing that criminal petition, Lordship. So in that criminal petition, stay has been granted and the complaint petition has been stayed, Lordship. Now the 4th respondent has approached this honorable court by filing this criminal petition, Your Lordship. So this may be tagged along with that matter, Lordship. That will suffice, Lordship.
So, and not only against those 4 petitioners, but for all it is state.
Or state. Whole complaint petition is state, Lordship. Proceedings in complaint petition has been state, Lordship.
It will be listed again. I can understand, but do you need to issue notice also here?
Lordship, it has come for motion. Probably notice is
Notice,
required.
issue notice,
Lordship.
because subsequently it may take together or it may be heard together.
Lordship.
But otherwise also it is a separate case, so better to issue notice.
Lordship.
Heard Mr. P. Board of Data and Contact. This. Gen- 528 BNSS against the order dated 29/4/2025, passed by learned GMFC Sipsagar in GR case number 177 and 34, rejecting the final order report submitted by the investigator. Issue notice to the respondent, also called for the scan copy of this. However, next it is submitted by Mr. Gordon that the 5 numbers of petitioners have 5 numbers of accused persons have already approached this court, and in wherein the entire criminal proceeding has been stayed. I'd order dated 17/7/2025 in criminal petition number 596 of it. Next, in view of this, let the present petition be listed along with the criminal petition number 596 of the list.
Oblige, Your Lordship.
May I please Lordship, 528 application, Lordship, on a BNSS for passing of proceeding, Lordship. What happened in this case, the petitioners and the informant, they are own siblings. The petition number 1 is the brother, and petition number 2, doctor, she is the sister of the informant. Due to some ancestral dispute, Lordship, property dispute, the other was lost. Now, Your Lordship will kindly see the statement of the wife of the informant. Page 36. Devojani Chaudhary. She is the wife of the informant. I am a homemaker. I was present in my home at the time of occurrence. At the time, my husband was not at home. Informant was not at home. The accused person named in the FIR, namely Biplab Chaudhary, is my brother-in-law, and my husband's sister, namely Bonani Chaudhary, who argued with me over ancestral property and says towards me. Thereafter, confronted and abused me with filthy language, and by threatening me, they pushed me. When my brother-in-law pushed me, my blouse got torn. They broke the doors, also damaged several household items. After some time, when my husband arrived, quarrel subsided. My husband went to the police station and lodged another. So this is the allegation, Lordship. And thereafter, what had happened, Lordship, they arrived at a deed of agreement. That is Annexure 5, page 51. All the informant as well as the present petitioners. They arrived with an agreement on 16 December 2021, and the occurrence incident took place in 2/5/2021. There, Your Lordship, kindly see in page 55, clause 18, that after signing of this deed of agreement between the 3 parties, each party shall withdraw all types of criminal, other related criminal or civil cases against each other. So they arrived at a compromise, Lordship. Because due to ancestral property, now they have settled the property dispute also. So my humble prayers also will kindly issue notice, and in the meantime, further proceeding may be stayed.
Yes, good. No, it seems that it is a family dispute. That
Family, own brothers, siblings, own siblings.
Yeah.
case is pending at present.
Pending at present, JMFC, Kamrup, Guwahati. And the offenses also 506, 352, 427. All
Charges-
minor offenses.
This has already been framed.
Right. All minor offenses. Lordship. Listen, listen.
Which is not compoundable.
Lordship.
Is there any non?
No, this is not there. 341, that cannot be because it is our own house. Then 506,
No, no,
352.
no, I'm not.
427.
Is there any non?
No. All are compoundable.
Then
All
why
are,
you have approached this court?
all are compoundable.
Why you have approached this
No,
court?
I have
for
come for quashing, Lordship. Because
Very
charges
well
have been
compromised.
framed. No, Lordship,
Can
that's
very
why.
well compromise.
No, as because charges have been framed. So I have come here. They will appear here. They will, if they compromise, here also it can be done.
Five Mr. Dita reported on possible. And it additional. This is an application. Section 528 BNS is for washing of the charge sheet as well as the entire criminal proceeding pending before the court of Learned JMFC Kamrup M in PRC case number 505/2024, whereby the charge has already been framed against issue notice to the respondent to register dating and as the process formal notices required for South State 1 for the scan of the PCR. Next, considering the submission made by Kiran and the nature of the allegation. Further proceeding against the present petitioner in connection with PRC case number 505 of 2024 is state of being suspended till next test. This the matter according to.
Much.
May I please, Your Lordship? The Lordship, the instant petition has been filed under section 528 of BNS for quashing of Sonari PS case number 196 of 2023 and PRC case number 80 of 2025, which is pending on CGM court Soraido. Lordship, the fact of the case is that a complaint was lodged by Sri Karuna De, son of Nakul De, on 16/11/2023, alleging that on 3/11/2023 at about 12 noon, his daughter, namely Akansha De, aged about 17 years, had some arguments with another girl, namely Loxi. It is alleged that petitioner, who is managing director of the Institute School Dibyolata Idol Academy, punished the both girls. The petitioner directed Akansha and Loxi to knee down in front of the class in a sign, and he even hit Akansha from the behind. After some time, daughter of the informant, Miss Akansha, became unconscious, and he even and fell down on the ground, and the informant further stated that Mr. Biswajit Burwa, who is the petitioner in this case, beaten up the daughter of the informant, Miss Akansha De. But if we go through the FIR, Lordship, Lordship, page number 16, in the FIR, Lordship, he states that actually at that point of time when the daughter of the informant was knee down before in front of the school, the MD of the said institution, Mr. Biswajit Bura, who is the petitioner, was roaming around the daughter of the informant with him. Where he was roaming around the daughter of the informant with a bamboo stick, but she did not realize that he is the person that he beats up her daughter or not. So out of doubt, he said in the said in the same FIR that Mr. Borua, who is the petitioner in this case, had beaten up her daughter. And after that, Your Lordship, at around after the primary treatment which was done by the school authority, they took the daughter of the informant to her house, and at around 6 p.m. on the same day, she again fell unconscious, and she has been admitted to Rajapukhuri Hospital, and doctor of the Rajapukhuri Hospital forwarded her to Assam Medical College. Lordship, on 16/11/2023, after the 13 days of the incident, the informant filed the FIR, and the same was registered under section 325 of IPC and section 75 of Juvenile Justice Act 2015. Then on 13/6/2024, the IO of the case has completed his investigation, and accordingly he submitted the charge sheet before the Chief Judicial Magistrate Soraidev at Sonari. Then in this charge sheet, Your Honor, it reveals that the victim was not a minor person. Section 75 of Juvenile Justice Act, which was imposed by the investigation officer, in the charge sheet, it is revealed that she was not a minor girl, and as such, Juvenile Justice Act is not applicable. So after this charge sheet has been filed under section 325 of IPC, Your Lordship. Lordship, in this case, it was mentioned in the FIR. It is mentioned in the FIR that another girl have been punished by the MD of the said institution, Mr. Biswajit Bura, whose name is Lakshi. But if we go to the charge sheet, Lordship, no statement of IO has not submitted any statement of that other girl, namely Lakshi. So there are many labs, Your Lordship, and even the FIR also, Lordship, are filed after 13 days of the incident. And Lordship,
So what is your prayer now for quashing?
yes, quashing and matter may be further proceedings may be stayed, Your Honor, and
So what is
notice
the
may be
stage at
issued.
this stage? What is the stage of the case?
Well, Lordship.
Charge has already been framed or not yet framed?
No, charges have not been framed yet.
Not yet framed.
Yes.
It seems the notice should go, I think.
It
Because
is.
case is a very,
Yes, madam.
against a teacher who. Now see, now girl may not be 18 or 17 years, or she may be more than that,
She is
or
already
20, 75 attracts or not. These are the matters to be for consideration at the time of hearing and the final. But prima facie, it reveals that the girl sustained some injury on her head,
Mhm.
and for which she became not only once, but twice she became unconscious.
Mhm.
So that is.
And Lordship,
So let us issue the notice first, and we will call for the scan copy of the TCR. After receipt of notice, I mean TCR, matter may be finally heard and decided.
Lordship, on the 19th of this month,
Matter is
next
picked
day
on
has been picked
19th.
for the, yes.
We'll try to accommodate you. See. What's your good name?
M. Kolita, Lordship.
M. Kolita. You are appearing for B. Bormon.
B. Burua, Mr. Biswajit Burua, petitioner.
No, you are appearing. Your name is not reflected here in the court list.
Oh, actually, maybe some mistake, Your Honor, but
No, your
I have
name
filed
is
in the Bokala, I have signed in the Bokala.
Akakama. Okay, then your name is
Minmay Kolita.
M. Kolita.
Yes.
So one name is reflected here, B. Bormon. It's a from.
Yes. He's the senior counsel.
Heard Mr. M. Kolita, the Daniel Counsel for the petition. Also heard Mr. R. Poshi, the Daniel Kolita for the petition, appearing on behalf of Mr. B. Burman. And also heard Mr. R. Poshi, the Daniel petitioner, appearing on behalf of. This is an application under section 528 BNSS for quashing of the FIR as well as charge it and the PRC case number 8 and the entered criminal proceeding of PRC case number 80 of the issue notice to the respondent. No formal notice is required to be served on state number 1. However, copy of the petition will be served during the course. Also call for a scan copy of the TCR. Next para, considering the submission made by and for the both the sides and nature of the case, I do not find pass any order on interim reading. I do not find it proper to pass any order on interim reading. Please the matter accordingly after 2 days. Oh, sorry, your petition is 79. Your case is picked on
1990. 19 September.
15. So we are listing it on 15 so that if it comes, then we can dispose of
20.
15, 1-5. Your matter is on 19. So prior to that, if any order is passed.
Obliged.
15.
May I tell?
Yes.
Lordship, this is for passing of the criminal proceeding, Lordship. The FIR, Lordship, page 11, Lordship. Mary, Lordship. This is hereby inform you that a person called Abdul Rahim has tried to molest and tried to rape my sister. And so when she went to buy chips from his shop, and when she stopped to do so, he had told my sister to kill her father at night. He also gave his mobile number and a paper chip to call him at night and come to meet and go for a ride. Thereafter, Lordship, on the basis of this FIR, Lordship, charge sheet was filed and the sessions page. The charge sheet also in the same tune, Lordship. The charge sheet, Lordship, I have charge sheet, Lordship, in paragraph page 15, Lordship. Page 15, relevant portion, Lordship, of charge sheet. The prosecution story of the case is that on proofs on the complainant sends lodged in a written FIR at about Abdul Rahim has tried to molest and tried to rape his sister. So in his shop when she went to buy chips from his shop, and when she stopped to do this, and then he told her to kill her father at night. So in the same line, Lordship. Then now the case is, Lordship, before the session is Lordship number 1, Kamrup, Lordship, session case number, Lordship. Yeah, Lordship, what happened? The petition number 1 is the informant. Petitioner number 1 is the informant. Page 2, Lordship, the details of the petition. Petition number 1 is the informant, Lordship. And petition number 2 is the Lordship, alleged victim, Lordship. And 3 is the accused.
It's a joint petition.
Lordship. Lordship, there the petition number 1, Lordship, is the informant. He has, Lordship, page 21, Lordship. The 11th page is page 22, Lordship.
The affidavit lordship found by the informant lord, married lordship. That I so and so and I am citizen of India by birth, and to that on so and so, this is the description of the FIR. That on 2/10/22, due to misunderstanding as well as being misguided, I lodged an FIR to the district police station against one Abdul Rahim, so and so, present resident of house number so and so, so and so, so and so, who is the permanent resident of so and so, which was registered as dispute PS case number under section 12 and subsequently charged sheeted under section against the Abdul Rahim for trial and now pending before the Honorable Court of Additional Session Judge number 1 Kamrup by session. And I had lodged the said FIR against him on misconception of facts and due to misunderstanding as well as being misguided. Therefore, I have no grievance against him and I am not willing to proceed with the said case. Pending before the learned session judge, Kamrup 1, paragraph 4, Lordship, that this affidavit is meant for the purpose of proving the fact that before any authority or any court of law that I have no grievance against Abdul Rahim, son of so-and-so, president, resident of so-and-so, with the permanent resident of so-and-so, and
They have subsequently compromised the matter, whatever.
No logical conclusion will be reached.
yes, Lordship, and
So,
page 24, Lordship, the affidavit also shown by the informer alleged victim also, Lord.
so now case has already been charged.
Lord.
Your charge has already been framed
No, no, and
Not
the
yet.
appearance stage.
Huh?
Appearance stage, Lord.
at the stage of appearance.
Next date is Lordship 11/9.
And going by this FIR itself, madam, 376 we got.
Not Lord.
But 376 is also not there. It is
there,
376 by 511 is there. Attempted.
It is attempt, Lord, attempt and
And as per allegation of one attempt was made.
everything. And actually, Lordship, I have annexed the judgment of your Lordship also, Lordship, that page 33, the judgment of, and the relevant paragraph is page 14, Lord. Page 38. Lordship. Mary, Lordship, after hearing the submissions made by the London Council for both sides and on basis of all annexures and statement made by the victim, it is seen that the FIR was lodged with the allegation of sexual assault on the victim, and accordingly it was registered under section 341, 354A, 376, 3 IPC, read with section 8 of the POCSO. But admittedly, there is no ingredient found in the statement made by the victim under section 164 and 164 CRPC to establish the case under section 376, 3 IPC. Further, it is seen that the informant himself appeared before this court with an affidavit of declaration that the case was filed by him only due to some misunderstanding and misrepresentation of facts and without deep thought and consultation. The FIR has been lodged at the heat of the motion. But it is seen that both the family members maintain a cordial relationship with each other, and as they are the family members, and the accused is also known person of the victim. As the matter has already been settled amicably between the parties, the possibility of making statement against the accused petitioner is removed and blanked, and accordingly, the conviction of the present petitioner is also cannot be expected, even if the proceeding is allowed to be continued. It is also admitted that the case.
Your charge sheet was otherwise filed under 376.
Yes, sir.
Was
It is
there.
already filed. And when we have reached to compromise or the affidavits were sworn when it was
Lordship, on 28/5/25.
after charge.
Lordship.
Apartments and that's not in the July Council for the also Mr. Other Oshik additional appearing of status. This is an application. Section 528.
Yes, my lord, the agreement is prior to searching. Agreement date is, my lord, this affidavit date is 28th day of May 2025.
Affidavits are 28,
May 25.
28 May 25 and
Charge
charge
sheet
date
date is 26/6. Oh, sorry, but 23, 2 years back.
prior.
Prior.
528 appearances. previous section 438 of the 440 of PNSS for praying for washing of setting aside the criminal proceeding in sessions case number 39 of the 2025. Bracket of ERC case number 1715 of the 2025. Bracket close arising out of this court case number 2213 2022. Registered under section 354A capital A oblique 376 5511 5506, which is accordingly charge sheeted by CS number 228 2023 dated 26/06/22 under section 354A 376 5511 5506 IPC and pending before the additional section number 1. Next. It is submitted by Mr. Mojumdar that the petition number 1 is the informant, petition number 2 is the victim, and petition number 3 is the accused of the present case who jointly filed the present petition for washing of the entire process. Mr. Mojumdar further submitted that the FIR was lost only due to misunderstanding of the fact as well as due to some misguidance. So there was no such though there was no such incident that happened on the day of comments. The matter has already been compromised between the parties, and hence the present petition has been filed jointly by all the petitions. Mr. Mojumdar further submitted that the petition number 1 and petitioner number 2, the informant and the victim respectively, had also swearing affidavit coming to know about the fact of the filing of the charge, wherein it is specifically stated that the FIR was lost by the petition number 1 due to some misguidance and misunderstanding, and the same is also narrated by the petitioner number 2 in her affidavit in her post. Next paragraph, Mr. Mojumdar further submitted that though the case has been charged and charge has already been placed, but it will be an abuse of process of the court, as if all the petitioners have already arrived at a compromise and there is less possibility of adducing any evidence against the petition number 3 by the vital witnesses of the prosecution, that is the petition number 1, the petition number. Rather, it will be an abuse of process of the court, and the conviction of the accused petitioner number 3 is also very bleak and remote at submission. Accordingly, it is submitted by Mr. Mojumdar that the entire proceeding along with the FIR and the charge sheet may be quashed by complying the provision under section 528 BNSS. It is further Mr. Mojumdar further relied on the decision of Honorable Apex Court reported in 2014 by SCC 364 in that context, wherein it has been observed that there may be a quashment of the proceeding in respect of non-compoundable offense on the basis of the compromise. Mr. Kaushik Didane should be submitted in this regard. that though the matter has been compromised, but it is seen that case has already been charge sheeted and charge is also framed against it. Oh no, it is appearance case, no? Party I forgot appearance case. Charge sheet has already been filed, considering the prima facie case against the petitioner number 3. Accordingly, he insisted for the district court to know the actual facts. Next, hearing the interest submission made by the responsible consents. It is seen that the case has already been compromised with the parties, and in pursuant to the said compromise, both the petition number 1 and 2 had already swearing affidavit stating that matter has stating that the case was lost only due to misunderstanding and misguidance of some person. Thus, it can be seen that even if the it is seen that the even if the case is allowed to be proceeded further, there is very little chance of adducing evidence against the petitioner number 3, and in that case, the conviction, there is the chances of conviction. Chances of conviction is very bleak and remote. Rather, it will be an abuse of the process. In case of Gyan Singh versus State of Punjab and another reported in 2012, then SCC 303 had laid down some guiding principles to consider the application in the section 482 CRPC and paragraph 61 of the said judgment to read as an it is also if the case started to do that. Let's say that. Considering the other all the other aspects of the case and also considering the fact of compromise between the parties. Is seen that as per both petition number 1, the case was lost only due to misunderstanding and for misguidance, and presently the matter has amicably settled between the parties and they are living peacefully. So considering all the effects circumstances of this case, and in view of the decision made, visit not the honorable effects and other aspects of the case, I find that a big case invoke the power under section 528 PNSS for setting aside and watching the charge sheet in number to charge sheet number 20 number as the entered criminal so and so pending before the done it with the above observation status disposed.
May I please your lordship? Lordship, application under 528, my lord, for quashing of a sick or direction passed by learned JMFC, my lord, whereby against the petitioner cognizance was taken, as well as the proceeding of CR case, my lord. Impugn order is at 173, my lord, page number 173. Order dated 3/4/2024, my lord.
Yes.
My lord. My lord, fact of this case is, my lord, in 2019, my lord, 25 numbers of
By this order, a cognizance take.
my lord,
You're challenging the order of cognizance?
of order of state cognizance as well as the CR proceeding of CR case, my lord. I have annexed the complaint petition I have annexed, my lord. My lord, the fact of the case is, my lord, this case is a little peculiar, my lord. On 2019, my lord, on 2019, my lord, 25 numbers of trucks loaded with terracotta nuts were seized by Guwahati police, my lord, on the ground that these are illegally procured from Myanmar and Indonesia by not paying GST, and these are foreign origin, my lord. Thereafter, my lord, this honorable court given a direction that where the cases of GST and custom is involved, the state police cannot seize those materials. After this direction, the case was handed over to the DRI, and thereafter the DRI has seized on the same allegations, my lord. Now, my lord, my case is I am the out of 25 trucks, my lord, I am the owner of one truck, one consignment, my lord. Now, my lord, kindly see page
You're
number.
the owner of trucks or
one,
consignment?
No, consignment, one consignment, my lord. My lord may see page number 7 now, my lord.
Page number?
Page number 7, my lord, my grounds. My lord, got it? Page number 7 of my petition.
Yes.
My lord. Now, my lord can see, my lord, the valuation of the consignment is, my lord, I am challenging this by, I have several grounds, my lord, primarily on 2 grounds, my lord. A, my lord, the consignment, I am the owner of the consignment valued rupees 37,30,125, my lord. And after paying GST and other requisite taxes, my lord, I have sent this consignment. And along with the truck and along with the consignment, GST certificate, index, and other requisite documents were seized. So there is no question of these goods being of foreign origin, my lord. These are local products, these are Indian. One aspect is that. And another aspect of this matter is, my lord knows, my lord, that cognizance has been taken under 135 of the Customs Act 1962, my lord. Now, my lord, in section 135, my lord, in the Custom Act, there is a bar, my lord. My lord, if the there is a monetary limit, my lord knows that if the consignment is under value 1 crore, my lord, then proceeding cannot be drawn against that. My lord may seek section 35 for a moment. Customs Act 1962. It will be. I have marked it, my lord, in the book, my lord.
Yes.
My lord, the consignment, those are valued under rupees 1 crore, my lord. The proceeding cannot be drawn. Thereafter, also, my lord, they have drawn the proceeding and cognizance has been taken, my lord. Now, my valuation of my consignment is rupees 37,30,125 as per my insurance, as per my valuation. And as per the department, my lord, my lord may kindly see page number 14. 14, my
Yes.
seizure of 2400 24500 kg, 320 bags, my lord, valued at 68 lakhs 60,000, my lord. As per the department, my consignment value is 68 lakhs 60,000, and as per me, it valued 37 lakh, my lord. Now they have taken it collectively, my lord. That cannot be collectively, my lord. My prayer and my argument is, my lord, either this is value, because I have my GST certificate and insurance paper has already been seized, and I have annexed with this petition also, my lord, that valuation can be 37 lakhs 30,125, or the department valuation is, government valuation is 68 lakhs 60,000, my lord. But they cannot be collectively both and calculated as 1 crore, my lord. This is my prayer. So, my lord, my prayer is LCR may be called for, and till then, my lord, the proceeding of CR case may be kept in abeyance.
Your lordship will have to obtain instructions. Your lordship. We haven't obtained instructions in this matter. Regarding stay of the proceedings, your lordship, it may not be granted at this stage, your lordship, because the dried areca nuts, as per page 54, your lordship, as they have claimed that it was indigenously produced. However, your lordship, the location which was given in Mizoram, there have been nil or no production of areca betel nuts in that area, your lordship. So
that cannot be the whole basis, my lord. And
your lordship, the LCR may be called for, until that stage, your lordship, no interim may be granted. Stay.
And moreover, my lord, Chested Calcutta has been the fine that was imposed upon me has been set aside by the Chested Calcutta, my lord. That order is with me. Can you that order? It has been set aside, and a remark has been given by the Chested that department could not prove that this areca nuts was foreign origin, my lord. In the last page,
Could not prove.
could not prove, my lord. The
Could
remark
not.
has been given.
Could not is really, I mean, different thing.
My lord.
Now, is it a case stage just
Appearance.
Huh? No. This judgment says what? They could
The
not prove it
fine-
for foreign origin or what?
My lord, the fine was imposed upon me has been set aside by the judge. I'm just giving it
by this
fact as a fact. My lord can
against fine you have.
Yes, my Calcutta, and that has been set aside.
Part MSSGR, Silvanate Council petition. And also part. Your good name?
P. Upadhyay, your lordship, on behalf of Mr. S.C. Care.
You appearing on behalf of SIPAC, Standing Council, PRI. This is an application under section 528 26 for washing. The order dated 3/04/20, but by learned JFFC in service number 7519, taking cognizance against the present petition under section 135 of the Customs Act, and also paid for the subsequent for washing of the subsequent law. Issue notice to the respond, however, responded to requests, however, as if Standing Council area has already represented the respondent, the formal notice is required to be served on the respondent. But during the course of deliberation, it is submitted by MS numbers. Ms. Upadhyay submitted that she needs some more time to take the proper instructions from the department. In that context, MS Gia, the learned counsel for the petitioner, submitted that the the present FIR, the present petition is filed on some, the present petition for quashing has been filed on some grounds. And and accordingly, she submitted that the present petition, she further submitted that the present accused petitioner is the owner of only one consignment, which was intercepted for only one consignment out of 25 numbers of trucks which were intercepted during the investigation. And she further submitted that the dried areca nuts which have been seized in connection with this case was for rupees 30, valued for rupees 37 lakhs 30,125, wherein the GST has already been paid and the bills cannot be of foreign origin. First, further she submitted that as per section 120, 135 of the Customs Act, a proceeding cannot be drawn for the materials valued under rupees 1 crore. And but here in the instant case has been already initiated. So the value of the areca nuts, which is only more than only 37 lakhs and 37 lakhs 30,000. However, the department has valued the amount at rupees 68 lakhs 60,000, 68 lakhs 60,000, and collectively taking into taking the entire value collectively had initiated a proceeding, which is not at all maintainable. She further submitted that the against fine imposed the present petition, they have also filed a petition before for the regional bench of court, regional bench by in customs appeal number 75646 of 2022, wherein the fine imposed on the present petitioner is also paid. Next, MS Padhay submitted in this regard that he needs proper instructions regarding the origin of the areca nuts, as it reveals that the areca nuts were from the state of Mizoram, where there cannot be any local production of areca nuts, and it is accordingly suspected to be foreign origin. Next, considering the entire submission made by for both the sides and the nature of allegation and other aspects of the case, I do not find it difficult to extend the privilege of stay at this stage, and accordingly call for the scanned copy of the PCR. In the meantime, the respondent will also file their written objection after taking the proper instructions from the side. This is the matter accordingly. It will be no stay is provided. It will be. Thank you.
Obliged.
May I please your lordship? Lordship is a 528 petition, my lord, for quashing of the order dated 25/2025, passed in PRC case number 170 of 2024, by which the learned trial court below, that is the SDGM Biswanath, has rejected the prayer for discharging the accused from this case, my lord. So at first, lordship, I would like to take your lordship to the FIR. Lordship will find it at page 26, my lord. May I read, Lordship? Complaint against Mr. Devasis Talukdar, dated 29/2/2024. Most humbly, I would like to let you know that I came across Mr. Devasis Talukdar, son of so-and-so, resident of so-and-so, on Instagram approximately in the month of March 2023. Since then, we had been talking via direct messages, DM on the Instagram. Mr. Talukdar claims to be a scientist of Indian Space Research Organization ISRO, placed at Satish Dhawan Space Center, Sriharikota. Mr. Devasis Talukdar also claimed to be an alumnus of Indian Institute of Technology. He said that he did his BTech in mechanical engineering from IIT Delhi. And he claimed to have done his master's in aerospace engineering, St. John's College, University of Oxford, England, and also showed me his pass certificate against the same. However, sir, since October 2023, he claims to be under suspension and that he is undergoing a lot of financial crisis. He asked me for some financial help and I gave a sum of rupees 20,000. He promised to return it by November 2023, but I did not get it back from him yet. Those things continued since then. And at the onset of February 2024, he started telling me that some people from his workplace, that is ISRO, wants to access some of his confidential files and has some bills against some of funds allotted to him. In the month of November 2023, he also sent two people to Biswanath Chariali Municipal Board, Hemango and Moheswar Bosumotari, who claim to be the proprietors of MH Engineer and Automation. They came and had a meeting with me regarding building of a solid waste management machine. On 14/2/2024, I received a message on WhatsApp from a number bearing so-and-so saying that it is Mr. Dr. Monish M. Mehta and that he is the ex-scientist of ISRO and he needs to talk to me about Devasis. I immediately blocked that number and after 2 hours or so, I received another from the same number on my other phone. I felt suspicious about the same and since then, sir, I have been having an apprehension that this man might have been conning me. He has been also harassing me mentally. I also believe that he has been conning the other people simultaneously and that he is a threat to the society altogether. May I therefore request you to kindly take necessary action against the same. So far the FIR is concerned, my lord, it prima facie does not disclose commission of any offence. He was arrested, the petitioner was arrested on strength of this FIR, my lord, on 1/3/2024. Subsequently, he was forwarded before the learned trial court and the petitioner preferred a bail application before this honorable court. My lord will find at page 28 is the order of this honorable court while granting the bail to the petitioner. Lordship may kindly turn to page 29. I just want to show Lordship one observation of this honorable court while granting the bail. Lordship will kindly come to fourth para, my lord, page 29. This court is of the opinion that there is a serious doubt about the existence of prima facie criminal case against the present petitioner. So that was the observation while granting the bail to the petitioner at the motion stage itself, Lordship. Thereafter, the charge sheet was laid, Lordship, on 30/4/2024. And interestingly, on the charge sheet, Lordship will find list of witnesses, page 32. There are altogether 6 witnesses, Lordship, page 32. But the name of the petitioner is not there. Complainant is not there, Lordship. Informant name has not been reflected in the list of witnesses, page 32. And the other 4 witnesses, Lordship, that is the Konkon Talukdar, Sinmoy Talukdar, Syam Kumar Sinha, and Siddharth Potim Kosik. They are the seizure witness. Now, an application was filed before the learned trial court by petition number 383 of 2025, my lord. Lordship will find annexure 4, page 38. Praying for a discharge under the provisions of 262 of the BNSS, my lord. In that particular discharge petition, all the things have been specifically mentioned. And so far the statement of witnesses are concerned, that was also mentioned that no prima facie case has been established by the prosecution from the charge sheet, my lord. There is no prima facie case against the accused. Then also, my lord, without considering the discharge petition, the learned trial court, without making any specific speaking order in respect of framing of the charge, by the order dated 25/2025, Lordship,
was pleased to frame the charges. Page 45, Lordship will find Annexure 5. Upon perusal of the case record and also hearing both sides on the point of consideration of charge, this court is of the opinion that there are grounds for presuming that accused Sri Devasis Talukdar has committed the offence punishable under section 419 of the Indian Penal Code, which the court is competent to try and punish. So, my lord, without having any ingredient of cheating, so far the FIR is concerned, so far the statement of the witnesses is concerned, the learned trial court, without going into the merit of the case in a mechanical manner, framed the charges against the petitioner. So there has to be, my lord, the basic thing, my lord, while framing the charge, the trial court have to consider whether there exists a prima facie case against the petitioner or not, lords. Without going into that finding, my lord, simply charges have been framed in a mechanical manner, my lord. Because so far the definition of cheating is concerned, lordship, that has been mentioned in section 415. The cheating, whoever by deceiving any person fraudulently or dishonestly induces the person so deceived to deliver any property to any person, or to consent that any person shall retain any property, or intentionally induces the person so deceived to do or omit to do anything which he would not do or omit if he were not so deceived, and which act or omission causes is likely to cause damage or harm to that person's body, mind, reputation, or property is said to cheat. So here, my lord, so far the property is concerned, apart from the statement that 20,000 was borrowed was lended to the petitioner. That apart, there is nothing, my lord. And that cannot be said to be there is any element of cheating. For recovery of that amount, my lord, there is a civil remedy if the amount has been given.
My lord, kindly peruse page 36. And last paragraph, my lord, the particular portion of the certificate. The certificate which he has produced, like my lord, he is ISRO scientist, IIT student, my lord. Those were found to be, my lord, fake. And my lord, he not only initially took 20,000, he again tried to do this continuously do the same. In fact, he sent some person, my lord, as per the FIR. Meet the complainant, they also tried to acknowledge more money. The thing is that, my lord, going by this thing, my lord, it seems, my lord, he is a fraud. And on what basis this order has been passed, my lord, for the record has to be called for.
So far that, my lord, if lordship allow me to submit, so far that certificate is concerned, my lord, he was arrested on 1/3/2024, my lord. He was taken into custody from his native place. He was taken to Biswanath Chariali. And so far the seizure list is concerned, it has been stated that on 2/3/2024, my lord, at the police station, he produced the document. His house was searched, nothing was found altogether. And in the police station, one photocopy of that document has been produced. Photocopy, my lord, that too a photocopy.
This part from this page 36, page number 36.
My lord.
It seems that even he appointment certificate, etc., was also issued by him only.
Yes.
For himself, for his own.
Yes.
These are
পদকে দাখিল কৰা গোচৰ উল্লেখিত ডিগ্ৰী চাৰ্টিফিকেট এপইণ্টমেণ্ট চাৰ্টিফিকেট ইছুইং অথৰিটি লৈ এছাইনিং টু দ্য ইছুইং অথৰিটি জেনুইনেছ বাবে পঠোৱা হৈছে উক্ত প্ৰতিষ্ঠানত কৰ্তৃপক্ষ লিখিত উত্তৰত জনাই যে তেনে কোনো লোক এপইণ্টমেণ্ট চাৰ্টিফিকেট দেৱাশিষ তালুকদাৰ ইছ্যু কৰা হোৱা নাই এছাইনিং টু দ্য ভেৰিফাইড ইট মাই লৰ্ড.
That will come, my lord, when the record will be called for, that will be reflected how that certificate copy of the police.
Dealing for my lord, in this under this section, my lord, this court is not a fact-finding authority, my lord.
Pardon?
This court is not a fact-finding authority, my lord, right now.
No, no.
While dealing this, my lord.
I am on prima facie, my lord.
Prima facie,
He is submitting that these witnesses are there, informant is not a witness. These are not matter to be.
I am on prima facie. Whether there is any prima facie case or
my
not.
lord, those are taken.
It seems prima facie is there. Heard Mr. P has stated.
My prayer will be that, lordship, the date is fixed on 10th.
Heard Mr. Anand Kaushik and it. So it's an application. Next. Issue notice very.
Lordship, before the trial court, next date is fixed on 10/9/2024, Lordship. Till returnable date, the proceeding may kindly be stayed, Lordship.
No, my lord.
Till returnable date.
Is to pass. No common notice is required, same type. Also call for a scan copy of the DCR. DC matter accordingly. You want any fixed date here? Fixed date even?
My lord.
He is saying that 10,
10/9,
we don't have any date.
Yes,
25.
he
It's
can
not
give time that day, my lord.
Because case is posted for evidence, my lord.
Take time.
16 month, be open 16, 17, 18, 16, 9. You text it for the respond number. It is not a
Lordship.
case for any state.
Obliged, Lordship.
May it please your lordship. Petitioner before your honor for praying for recalling or setting aside the NBW and PNA issued against the petitioner, your honor. The petitioner herein is accused in a NI case, your honor. In NI case number 3520/2017 pending in the court of Judicial Magistrate First Class Kamrup at Guwahati, your honor. After receiving the summon, petitioner appeared in the court and expressed his willingness to settle the matter. Yeah? Accordingly, matter was referred to mediation, your honor. I have annexed the mediation agreement in case number 30, your honor.
My lord, this is a NI case, my lord. So notice has to go, my lord. We are only one party.
Your honor, let me submit it. Mediation agreement case number 30, your honor. I have annexed on. Oh, 13. 27, your honor. Mediation number 27. Case was filed for dishonor of shake amount of rupees 2 lakhs, your honor. Accordingly, mediation agreement was signed between the parties and accused agreed to pay the rupees 2 lakhs within the month of July 2028, your honor. 2018. And he pay, as per the mediation agreement, he paid rupees 80,000 and rest of the 1,20,000 still pending to due, your honor. The accused is now willing to appear before the honorable court and he would.
Why he fled away?
Sorry?
Why he fled away?
During the the case was posted for DW before COVID, and after during COVID he miscommunicated with the advocate, your honor, and that's why he could not appear. I have also
So now since when he is in absconding?
2024.
Show me the order.
'39 case now. Police never searched him in the house, your honor. He is in Hangarabari, your honor. But report came that he has not found, your honor. It is true that due to his absence, NBW issued, but now accused is willing to appear before the honorable court and he is willing to pay the rest of the amount of rupees 1,20,000 with prevalent bank interest within 15 days from his appearance before the trial court, your honor. He will deposit the 1,20,000 with bank interest, your honor. Prevalent bank interest from the date of filing of this case, your honor. Within 15 days. My humble submission that warrant may be recalled and I may be allowed to appear before the trial court and I will deposit the rest of the agreed amount, your honor. Even in the cross part, complainant agreed to withdraw the matter if the accused paid the 1,20,000, your honor. In case number 31, your honor. Within 15 days, he will deposit it with interest, your honor. So I may be allowed.
Okay, within 15 days, 20 days, you are going to do. Why you are, I mean, since 2000, it was settled when? Before mediation, it was settled?
You know, I have annexed the medical documents, your honor.
No, before mediation, when it was settled?
In 2018, your honor.
2018 itself, it was settled.
Yes.
Before mediation.
Before
Then
mediation.
see,
He paid 80,000.
no, whatever. Then see, around 6, 7, more than 7 years, he is absconding.
not absconding, Your Honor. He appeared before the court and due to
No,
his,
no, till now he is absconding. That's what I'm
now
saying.
due to his failure to pay the amount, the proceeding was again started and complaint was duly examined, Your Honor. And the case is now in the stage of DW, Your Honor.
Yes, I know.
Yes,
I'm saying thereafter he is
there
now
is
absconding.
negligence. Admittedly, there is negligence on the part of the petitioner, but now he is willing to pay the amount, Your Honor. That maybe I will be protected so that I can appear before the tribunal, and I will pay the rest of the amount with equivalent bank interest before.
Mr. Pena, the learned counsel for the petitioner. Mr. R. Bosch, the learned petitioner, PP, appearing on the it's an application. For so setting aside the orders of issuance of NTWA and PNA by the learned Court of DMFC and petition in CRPS number 3520 2007. Issue notice to the response over basis on state number. However, copy of the petition may be served during the course. Also call for this can. Next question is submitted by Mr. Neo that the one is contributed by the respondent number 2, which was accordingly referred for mediation. And in the mediation, both the parties arrived at the settlement and amount was fixed for rupees 2 lakhs. Out of 2 lakhs, the petitioner had already paid his 8,000, but due to his illness, some other reasons, he could not pay the remaining amount of rupees 1,20,000. And during COVID, he could not make any contact with his NPS funds. Due to non-payment of the agreed amount, the case was further proceeded and the PWs were also examined. The case was fit for DW. Then at this stage of DW, what is your explanation? Why you have absconded? Since 2024, why you have absconded?
Miscommunication with the advocate.
Again,
and
miscommunication.
I have enough medical documents.
What is the ground? Miscommunication, medical, what is it?
Medical, actually, he is suffering from several rheumatological problem, Your Honor. I have annexed all documents, Your Honor. He is almost in the bed, Your Honor.
When the matter was fixed at the DW, he again could not make any conflict with his NPS counsel due to his severe illness, who is suffering from several hematological problems. However, presently, the accused petitioner is ready and willing to appear before the court and to pay the remaining amount of rupees 1,20,000 with the bank interest if he is provided with some interim protection so that he can appear before the learned trial court. Considering the submission made by learned counsel, I have also paid the record, and it is seen that initially the present petitioner was appearing, and it is also a fact that matter was referred to the mediation, wherein the parties had entered into an agreement. But subsequently, he failed to repay the entire amount, and also did not appear before the court regularly. However, at present, the petitioner is ready to pay the remaining amount of rupees 1,20,000 along with the interest before the considering this aspect of the case, I find it difficult to extend some interim protection to the present petition. When the case is fixed next day,
Fix on 14/10. I will appear within 10 days here.
within 15 days I'm given. Within 15 days from the date of order. Date of order, and will pay for regular pay, which may be considered in accordance with order till 15 days. No force, no the order of issue, but till 15 days, the NBW and DNA issued against the present petition, we stay of existence. We are giving.
Publish.
Yes.
May I please? Well, this is an application for the quashing of the FIR, my lord, and the substance. And the consequence, my lord, the charge sheet and the order of the cognizance, my lord. Well, absolutely the civil dispute appears to be in the prima facie, my lord. The informant, my lord, in this case, my lord, he pretended to be a judge, though he is a member of a tribunal, my lord. Probably he was not happy because he was not treated as a judge, and he has influenced the police to register the case, admittedly, my lord, from the document itself. Lordship, kindly see the page 27, the FIR itself. Now, what happened, my lord, in this case, he has taken the one flat from the petitioners, my lord. Petitioners are the promoters. And in 2023, they have entered into the agreement. And thereafter, flat was allotted, and accordingly, he was also allotted a place for parking, my lord. But the subsequently, he has used that particular parking for 1 year. And thereafter, that parking was subsequently, when all the people came to the society, my lord, formed a society, it was re-registered, and that allotment was changed, my lord. And that is his grievance, my lord. But you kindly see the page 27, my lord. FIR.
Parking was allotted first.
Parking was allotted, he used it for 1 year, my lord, initially. It's not a case that it was not allotted, nothing. It's his own admission, lordship, kindly see page 27. With the reference to subject cited above, I have hereby informed you that the manager Suman Saha has shown the parking number 100 of E block of Rudraksh Infotech in the flat number 101 E block, being satisfied with the parking number 100 and E101 that the said flat is purchased. The manager showed me a price of the list of the parking is satisfied. I have purchased the parking number, paying 4 lakhs, but after 1 year, the parking number is allotted to other person instead of me, ma'am. That is his grievance, madam. I vehemently oppose the allotment of the parking by sending email to the builder requested to allot the parking number 100. At the time of purchase of the flat, manager has given the price list without any sign and seal, which is necessary to proceed with to the RERA Assam, but the manager Suman Shah and the builder Rajiv Sanseti has not signed the seal, but the builder Rajiv Sanseti has dishonored me as a judge and defamed me as a lord. That is the grievance, my lord. Where is the criminal case, my lord? Non-allotment of it was allotted to him. Subsequently, it was changed. So he has 1 year, he has used it. Subsequently, it was re-allotted after the society was formed. Then his grievance is that, my lord. He has to go to the civil court for that, my lord. Where is the case of the cheating, misappropriation? Nothing, my lord. Then he has, my lord, as per the.
Not approach before RERA?
He has approached before the RERA. It was, my lord, lordship, kindly see the RERA order, the page, my lord, 105. It was dismissed, my lord.
His petition was dismissed.
Yes. Because it was allotted, subsequently it was changed, my lord. So realize it's a premature, my lord. It's not a case that here it's not been given to you, my lord. Just given, subsequently it was re-allotted, my lord. And the agreement also, my lord, as far the agreement is concerned, there's no specific area is demarcated for parking as per the agreement here.
But as per FIR, he was parking number.
Yes,
100
yes,
was
as per
allocated.
FIR, but if we go by the registered agreement, specific, well, there's no, only the parking area will be allotted, that's all, my lord. Nothing. My lord, you kindly see page 49. G point. Page 49, man. LOT has applied for an apartment in the project application dated so-and-so has been allotted 101 E3A area of so-and-so, carpet area so-and-so, floor area so-and-so, one covered car parking space as permissible under the applicable law. That's all. That's the agreement. And going by the FIR itself, my lord, it can be, it's a civil dispute, my lord, if he wants that particular space itself, my lord. But he used to use it, my lord. Last 1 year, my lord, but he was using, my lord.
So now cognizance has been taken.
Cognizance has been taken under that, my lord.
Case is registered under which section here?
420, my lord, that now the 316, my lord, the lordship will find the cognizance order, page 46.
Yes, that's.
Otherwise, if I look into the FIR lordship and the charge sheet is also the same lordship, he has went to the RERA also, it has been dismissed. Moreover, at this stage, notice maybe it should. Otherwise.
Administrator M. Bora, Learned Senior, assisted by. Who is assisting him? You are.
MS Hussain.
MS Hussain,
My lord.
assisted by MS Hussain. Comes for the petition, law, administrator. And then thus, the learned additional PP appearing on the an application section. When source in so for washing the FIR, charge sheet as well as the proceeding against the present petition pending before Court of Learned GMFC Kamrup M in PRC case number 1481 of the whereby the cognizance has already been taken against the accused petitions to task and issue notice to the respondents. No formal notice is required at this status number 1. However, copy of the petition may be sent to the post. Also call for this cat of this heard on interim review is submitted by Mr. Bora that the present petitioners are they have not committed any criminal offense as alleged in the act. It is the fact that there was an execution of deed whereby the informant was allotted. The informant had purchased one flat along with a parking space a parking space, which also already reveals from the FIR. And after using the said parking place for about 1 year, there was a dispute in regards to his allocated parking space. That part is, and which is, and it reveals that the case is purely civil in nature. And the petitioner and the informant also moved an application before the data, which has already been rightly dismissed. And thereafter, only with some false and concocted allegation, the present FIR has been used. Moreover, from the prima facie, from the statement made in the FIR, prima facie, it is seen that prima facie there is no criminal case against the present petition. And accordingly, it is submitted that till the disposal of the present petition, the proceeding against would the petitioner may be stay. Next, Mr. Thus, the learned petitioner PP submitted in this regard that PCR may be called for to know the other details of the case. Expert hearing the submission made by unconstitutional. After perusal of all the annexures filed along with the petition, other case, I find it difficult to send the privilege of stay to the present petitioner, with both the present petitioners, and accordingly the proceeding against petitioners pending before the court of learned James FC so and so in PRC case number so and so be stayed till the matter according to
Right, please, Lordship. Lordship, it was Jimma petition, connect, it was Jimma petition, Lordship, connection of this previous case. Corrected to Lordship.
earlier it was rejected.
By the earlier rejected. The special
So
just.
we can at least call for the report at least. You are Mr.
I Islam, Lordship.
By Mr. I Islam, the petition also by Mr. Arthur Kaushik. Learned petitioner PP appearing on state respondent. Call for the report from the concerned police station. What kind of thing with Jimma? Jimma of what? What nature?
Lordship.
It's a car, vehicle.
Car, Honda CBC car.
Honda
Three loads of chain gold and 2 pairs of earrings, Lordship. One chain, one iPhone, one Oppo mobile, Lordship. And 4 loads of checkbook, Lordship. And
seeking Jimma of the seized articles as reflected in the seizure. Report of Jimma and it shall be to the systems following the report. Estimate recording. The listing it after 3 weeks, let the report be given.
right.
Yes, Appeal.
Is there
It's a criminal appeal.
appeal against the judgment of 25/6/2025 passed by the special judge Poxo. Bonegam.
At this stage, no, this should go, POXO case.
There is a IA also for suspension of sentence.
In favor.
Lordship, your Lordship kindly come to page 15. May I read, Lordship, operative portion of the order? The bailer got opportunity for almost 1 year and 7 months for production of the accused person, but he failed. Therefore, we find it fit to forfeit the bail bond executed by the bailer, such and such, for accused such and such on 18/4/2021. We therefore find it fit to ask the bailer, such and such, to pay penalty of ₹1 lakh. That is illegal, Lordship. It is only bail bond amount in terms of section 446. Bail bond amount is 20,000. Lordship, I have annexed the affidavit. That is at page 29.
So not so much of query that whether this penalty is there.
Penalty is there.
There. Yes.
So penalty is there, but your bail
Yes.
bond is of 20,000.
Yes, Lordship.
Bail bond is something
It should be forfeited, and then if he not paid, then penalty of that particular amount.
No,
It is clear in the provision.
Oh, I don't think there are some provision. Yes, Goswami.
Yes, 446.
446, Lordship.
No, proceeding is under 446. Penalty under which section?
42(2). 42(2). 42 subclause 2.
Of CRPC.
Lordship.
442. No?
That is to general provision or what? 42. You are saying 42(2).
42(2). May I read the Lordship particular provision, Lordship? The court shall record the ground of such proof and may call upon any person bound by such bond to pay the penalty thereof or to show cause why shall not be paid. Then, Lordship, under clause 2, if sufficient cause is not shown and the penalty is not paid, the court may proceed to recover the same as if such penalty were a fine imposed by it under this rule. So, Lordship, at first it should be forfeited and penalty imposed, and it is that particular bond amount only. But learned court below, Lordship, penalty imposed a sum of ₹1 lakh, agreed by that petitioner before your Lordship. At this stage, Lordship, notice may issue and the date may be fixed, Lordship. Record also may be called for. Further proceeding may be stayed.
Next date.
Such.
So may kindly see the order, my lord. Feel helpful. Feel helpful.
Okay, good.
File this appeal again.
Yes, there is.
It is a appealable order, Lordship, under section 414.
They'll wait. They'll wait to see.
This order has been passed by session judge,
Lordship, it is additional session judge,
whatever
Ah.
session.
additional district and session judge, FTC.
So
Vijay.
what you want to stay? What proceeding you want to stay now? There is no such proceeding.
Yes, it is a
446, entire 446 proceeding.
proceeding.
Is
At
there
this
any
stage,
prayer?
it may be stayed, Lordship, till disposal of this appeal, Lordship. Not the original main case,
No,
Lordship.
that
It
is
is
understood.
a ancillary proceeding, Lordship.
So
A
that-
mistake
that-
registered against the petitioner, Lordship.
446 proceeding is registered. Is there any?
Lordship, yes.
Miscase
Mistake number B10 of 2020.
10/2020.
Lordship. And session case is Lordship 2/187.
It's okay.
That is
Now whether you have made any separate prayer for stay or here it is stay itself.
a Lordship.
Prayer for stay is there.
Lordship. It is prayer is there, Lordship, page 10, Lordship, and 11.
Okay, Goswami will see to it. Because 1 lakh, I think I'm also just confused because generally what happens if there comes, it stop there only.
Yes.
So whale bond is already forfeited and thereafter the penalty was there.
Penalty was there. But
You also see it is next week.
I'll see to it, madam. Those may kindly fix it after 2-3 days, madam. Maybe.
2-3 days this matter.
Yes, madam.
Okay, if you want to pay this.
Yes. Because
Otherwise, we can hear the matter or he is seeking for stay.
yes.
Stay of the.
Because already, madam, because already one date has gone, because by 12/8 he has to fix the pay the madam money.
On that occasion, the time was granted by the
The
land.
next before the next date, we can lordship can make him next date.
September.
September. Before the next date, it can be fixed. Madam.
September, can you tell us the date?
Lordship, I can take the date, Lordship.
Because 12/8 is the date for payment, madam. And what thereafter what has happened, it is not reflected here, madam. So
We don't have time today also.
before the next date, it can be fixed, madam.
The short date we agree. He will also make some assumption.
Next Monday.
So not in a next Monday, you are saying? Okay then, we are listing it on Monday. We don't passing any order. Listing.
Whether the amount, I only see what is the amount, madam. If it is
Amount.
any, madam.
So that has
yes.
to be seen, but the penalty is obviously there, but amount is to be 1 lakh.
So amount is very, so that has to be, madam. Whether it is.
The rest of the matters, we don't have any order.
Item number 34.